So thank you all for coming today. My name is Baldwin. This is how to make effective use of the Court of Protection in cross-practice cases. And this event is also being live streamed. So there are people out there in internet land watching us all. So just to identify what we plan to cover today, this is slightly an unusual Court of Protection seminar stroke conference, as we are engaging with other practice areas as well as the Court of Protection. And the conference is designed to demonstrate how to make effective use of the Court of Protection and its related jurisdictions of the High Court in very complex cases. And it's really aimed at solicitors and paralegals, local authority lawyers, lawyers of public bodies, litigation friends and court and staff users. If you're not on that list, you're still welcome to participate in this conference, but it's aimed pretty much at everybody who uses the civil courts and uses the Court of Protection, both on both sides of litigation. So we hope to give people an understanding how issues of mental capacity and how to assist protected parties make relevant decisions and how they can arise within all sorts of proceedings and to make effective use of the Mental Capacity Act and the Court of Protection in resolving complex disputes in different jurisdictions. So enough of my comedy routine. I'm now going to turn over to Felicity, who's going to give you a broader outline of what we're doing today.
Thank you, Tim. And thank you everyone for attending on this rather wet and dismal day. So we have a very busy programme ahead this afternoon. We're going to begin in this room with a discussion of the Supreme Court case of T, in which no less than 3 members of Garden Court Chambers Court Protection team were involved. And then we'll have a short break for refreshments before going into our breakout sessions. Those that are attending the housing session will remain in this room, and then we have community care and education taking place downstairs in conference room 2, which is on the ground floor. If you go through the main rooms at the bottom of the stairs, you'll be directed to conference room 2. We'll then have another short break and then 2 further breakout sessions on mental health care and aftercare, and that will be in this room. And then another breakout session in conference room 2, again, in relation to immigration detention. And then we'll hope to finish fairly promptly with at 5:10, with closing. And then hopefully many of us will be able to stay for refreshments at 5:30. So I hope you have a very productive and interesting afternoon, and we look forward to an active and engaged session. Thank you very much. So I'll hand over now for our first session, and that is going to be with Weston KC, Meusz, and James Holmes.
So I'm Amanda Meusz, not the clever Amanda Weston. And I'm starting. So I represented the local authority unusually at first instance in Court of Appeal led by Amanda Weston, and in the Supreme Court in the case of Wright. And we thought that it would be more productive to give you an outline of how the case found its way to the Supreme Court and the context of the case as opposed to the decision made by the Supreme Court, which was clearly that a child could be placed in an unregulated provision and could have her liberty restricted in such a provision. And we know now that things have changed. There are new regulations and guidelines and the national policy. But really to set the scene, we also know that the High Court, the Court of Appeal, so Wright found its way to the Court of Appeal, and the Supreme Court in the context of what Sir James Mumby, a former president of the Family Division, called a national scandal relating to the lack of provision for very troubled and damaged young people. So the context for T is that she found herself in the care system from a young age. She had suffered multiple adverse childhood experiences. She had spent a long period in secure accommodation, which is the, I'm not sure how much the audience knows about the Section 25 and Section 119 of the Welsh legislation relating to secure accommodation. But this young person had spent a long time in secure accommodation. She was transferred to step-down specialist provision. That breakdown, she found herself back in secure accommodation. So unusually, the proceedings started. This wasn't a place where there was a physical gap of provision. There was a place, a physical place, available, but the accommodation refused to have her because they felt it was not in her interest to remain in secure accommodation. But she still required bespoke care. She still required very significant restrictions in relation to her personal life. And so, the local authority applied under the inherent jurisdiction to place her in a bespoke placement and to restrict her liberty in various ways. The application was granted and approved by Weston KC, and get an overview of the case. When sitting in London, the issue relating to the young person's consent became an issue. And I think for Court of Protection practitioners and those who do the sort of crossover work, the 16, 17-year-old work, it's not so much the Supreme Court case that it will be interesting and relevant to you, but what the president of the Family Division said in the Court of Appeal. And once we got to the Court of Appeal, before the Court of Appeal, those representing T said that she is quite content to go into the specialist placement. She consents to the deprivation of liberty. She has capacity to consent, and therefore the court should not make a deprivation of liberty order. Mostyn, at first instance, was persuaded to go along with this, although he was confused. And so he was persuaded to consider the issue of her consent. But when he looked at it, he decided that, in fact, T was not able to give an enduring and authentic consent. And that was really because of the extent of her troubled behaviour. So she knew sometimes that she needed safeguarding, she knew that she needed restrictions to keep her safe, but when triggered or distressed, she would break those restrictions and try and escape her. So Weston found that her consent was not authentic and not enduring. In the Court of Appeal, the appellant really based her appeal almost solely on the issue of consent. So it's very different from the position in the Supreme Court, when it was argued that there was no jurisdiction to make the orders that had been made. So in the Court of Appeal, the Lord Justice McFarlane considered at great length, and I'm not going to take you through it, I've outlined the paragraphs, from paragraph 23 onwards, this Court of Appeal judgment, that there's a long argument about consent, starting with Cheshire West and Storr. I think for you guys, it would be really interesting to look at the Court of Appeal judgment, because there is considerable analysis by the President of the Family Division relating to the issue of consent. As you see, I've set out in conclusion, McFarlane found that the need for there to be an absence of consent was not necessary in order to make the deprivation of liberty order. And he went through some of the older cases, the De Wilde case, which preceded Stork, and then he considered M&M and Re J, and made it very clear that individuals' consent is not, the issue of consent is not something that is necessary when considering such important matters as deprivation of liberty. The Supreme Court did, when they looked at this, so by the time the case was in the Supreme Court, the issue of consent was a subsidiary issue. And Lady Justice Black, in her very lengthy judgment, really agreed with Macfarlane's analysis and said that the issue of consent is really something that would be looked at on another occasion. But so we're left with Repeal's analysis in relation to consent. It's really standing. That's really the background. The young person in this case was really was never really ripe for a transfer to the Court of Protection. This was always the case that was going to sit within the inherent jurisdiction because of her trajectory through the care system. So in this case, the issue of competence and capacity was looked at in a very broad way. So it was decided really without very much analysis that this young person was Gillick competent. But her capacity to consent to specifics was not ever properly analysed. It was just accepted that she had capacity to consent, and I think it's something that may have been questioned. Was my personal view. So that's really the context of, we know that in 2018, Lord Justice Macfarlane said that he was troubled by there being 150 applications under the inherent jurisdiction for the deprivation of liberty. This, in the last year, between June 22 and June 23, the applications to the National Doles List have gone up to 1,200. Almost tenfold. But I'm going to leave others to talk about that. I'll ask you questions later, but I'm going to hand over to James to update you.
Thank you, Amanda.
Start, because you're going to go on to the post-RET picture, and James is going to deal in more detail with the post-RET regime and the National Doles Court. But there were just a couple of points I wanted to make, picking up from what Amanda said. She's absolutely right to focus on the issue of consent, because what it's sometimes easy to forget is that the purpose of Doles isn't to bang people up. The purpose of Doles and the purpose of the process is to ensure a mechanism to secure oversight. And consent, if children were able to consent, or if young people were able to consent to their own deprivation of liberty, that would effectively disenfranchise them from the oversight, if a consequence of consent was that it was no longer a deprivation of liberty as defined by Strasbourg and Cheshire West. So that's the sort of key issue to remember about why consent can sometimes work against the interest of a young person. And the other point I wanted to make was this: one of the reasons that the Supreme Court was satisfied that there wasn't a breach of Article 5 in RET was because of the extent to which the presidential guidance provided that the courts would supervise the process of registration or some degree of oversight of placements in unregulated placements. But the President has recently, just within the last couple of weeks, issued guidance making it plain that it is not the court's function to offer that degree of oversight. And it's not the court's function to go through the process of monitoring the extent to which unregistered placements are complying with their registration requirements, etc. Therefore, my humble view is it's only a matter of time before there's RE-T2, and that's because there's real problems about the extent to which, in the absence of that oversight, the current process is compliant with Article 5, in that there is a risk, and the argument's already been run once, there is a risk that the courts will determine that the deprivation of liberty of a child in an unregulated or an unregistered placement wouldn't be by a process prescribed by law for the purposes of Article 5. So I just wanted to flag up that current sort of, and then at that point hand over to James.
And that must have come about because of the tenfold increase.
Yes. It's not the court's function, and I think the President makes that clear.
Yes, so as Amanda was saying, is that following this, the President set up what we call in family courts, the National Deprivation of Liberty Court. That court was created on the 22nd of June of last year, with its first case being heard about 6 days later. As you will see on the slide, some of the statistics from the National Deprivation of Liberty Court, that being the majority of the applications, 151 of those are made by local authorities. There are a few hospitals and mental health trusts, and I will be talking later about with the applications there's been one application made by a hospital trust which hit the news. That you will also see that the majority of the applications are involving children who are aged 15 and above. There are very few that go under that, and there is not any at the moment clear reason why there is that distinction. That the vast majority of the applications are being made due to signs of physical and verbal aggression. There's about 69.2% of those cases have that as a key risk factor. That the children there are, and surprisingly, there were 7.2% of the cases of the 1,000 or so, just over 1,000 in a year, involved children under 12, which I think raises a concern of clearly there's a lack of provision about what is being going on and so forth. Why was the National Doles Court created? That there's many reasons. I think one of the reasons mainly, as you will see, is greater transparency, and that is having a central court which can be monitored by organisations, because what you will see later on, and I will raise those here, is that the Ministry of Justice have no obligation to put out any sort of statistics in respect of these applications, not therefore knowing what information and what are the concerns are. The other purpose of the National Deprivation of Liberty Court, due to concerns in it, was trying to have specialist judges who have received some more specialist and specific training dealing with these applications, because there was, and I think found, a varying approach to these applications depending on which part of the country you were, the expertise of the judges. And that was also, and goes to, I think, the point Amanda was touching on prior to the new guidance, is that how and what the judges should be looking at about the placements that were being proposed to put the children into. Most of them were unregulated. What safeguards should be put in place? What are the obligations on the local authority? There was a point prior to that, it really did depend on which judge you ended up in front of if you were outside of the High Court, about the approach that was being taken. And also the other point on that side is to say that due to the increasing number of applications, it was felt it was more appropriate to have, I think at the point it started, 2 High Court judges supervising a number of deputy High Court judges to resolve these applications in a fair and expeditious way. On the next 2 slides, I have set out the differing mechanisms that and approaches that can be taken in respect of young people between the ages of 16 and 18. You will see that there is the more common one, which those in this room may be more familiar of, is in respect of applications to the Court of Protection. But as those in this room appreciate and understand, is firstly, you have to be over the age of 16. You have to be deemed to lack mental capacity. and that is a limitation to the approach currently, which I think those who were becoming familiar with the proposed liberty protection safeguards was going to partially resolve certain issues to allow the Court of Protection to have a broader, wider ambit in respect of young people over the age of 16 if they were in specific accommodation. But as we all know, that is at some point in the future, if at all, when that will be now happening in light of recent parliamentary views and statutes that are in place. Just to highlight on this slide, I have mentioned REX. Those that do Court of Protection and also family. The case I'm referring to is the Court of Protection case, the REX of 2014, because as those I will speak about the other case in a bit later, there's the REX case of 2002, which goes all about secure accommodation, secure accommodation and lack of provision. The REX procedure here was dealing with the streamlined process that was put in place by the Court of Protection to deal with approving deprivations of liberty. So I just thought to flag that. On the following slide, I set out the two other statutory-based schemes and approaches, that being the secure accommodation under Section 25, and I set out the brief test applicable in respect of that. And then you also have the approaches that can be undertaken under Section 2 and Section 3 of the Mental Health Act. As I probably should have kept in the other order, but had the inherent jurisdiction on the slide that then followed. The inherent jurisdiction is not statutory regulated. That is part of the inherent jurisdiction of the High Court. It has always been a procedure that has been in place since the High Court itself has been in existence. All the other three schemes in that sense have a basis of statutory regulation in a statutory approach, and then an obligation upon organisations, which the inherent jurisdiction doesn't. And as those and we all know, it plugs a gap. When there's a gap in approach is that can be taken. What do we do in respect of individuals? And when there is not a solution to the problem that the court faces. I want to deal with now at this point is the question I think we all encounter when we have young people between the ages of 16 and 18, whether we use the Court of Protection and an application should be made there or the family court. And that is a question I think we always should have at the front of mind when we have cases presented to us of individual or cases, clients, professional clients or lay clients coming to us and expressing a concern in respect of 16, 17 and 18-year-olds, which is the most appropriate court. It was confirmed by the president or the old president, Mumby, in the case of ANF, Children number 2, 2018. It was confirmed that the mental capacity and the Court of Protection and the family court run parallel with one another. Neither has an overarching jurisdiction. It was raised in Re-D by the official solicitor, whether because there's a whole package available under the mental capacity, and that is the approach and that is the statute, and therefore the Court of Protection is the correct tribunal to deal with such applications. But it was put, Lady Justice Black in the court, in the Supreme Court, quite rightly identified that that was not, in fact, correct. There's the either or option. When looking at whether we should be putting a case or bringing a case in the Court of Protection or the family court, whilst the transfer of proceeding rules that I have set out on the slide in front of you is not applicable at the point in time of deciding where to issue. They are very useful guidance in respect of questions the courts will be asking themselves if they are and have cases brought before them of what approach should be taken in respect of that. The slide in front of you is in respect of questions of transferring from the Court of Protection to the family court, but they are very much in similar words on both in both sections of that act. I don't think many family practitioners are as well adverse of that transfer of proceedings as we may be in the Court of Protection. set out on the slide is two cases that took very different approaches to the question before, when they had a question of young people between the ages of 16 and 18 and which is the correct and most appropriate court. The varying approaches that were taken. In the case of B, there was the situation of a 17-year-old for Headley J, and who was deciding on where the local authority brought care proceedings because the mother in that case could not meet the needs of the young person, and that the question that was raised was at the very end, and it was actually by the judge, was whether it was the most appropriate for the family court to be making care orders and orders about this young person, or whether they should be in fact be transferring the proceedings to the Court of Protection, for the Court of Protection to be making best interest decisions, other decisions around where she was going to live, questions about deprivation of liberty. Those were all issues that he raised. In that case, he felt that because they were lifelong conditions and diagnoses and difficulties that she had, that the most appropriate court to be making decisions was the Court of Protection, and therefore he transferred it. But as what all High Court judges do, is just sat in his seat, span around and started again and said, I'm now in the Court of Protection. Didn't make anyone do anything different. So he dealt with that. But then what happened in a case about 8 years later, the case I referred to where Mumby had the case, the issue was in respect of there were 7 children, all with varying different needs. 2 of the children were soon to be over 16 and had issues around capacity, and so did some of the younger children. And the question was raised at that point whether the High Court should be dealing with the matter of protection. Taking into account you would be soon having 2 young people turning to the age of 16, and there'll be long-term decisions being made in respect of her and them. And what Mumby decided is that no, it shouldn't be transferred. The family court is best placed to deal with such applications. There is better oversight from an IRO, that there'll be issues in respect of the role of the guardian. So in that sense, in those who are not familiar with the children cases, is instead of having the official solicitor representing the views of the child, you have the guardian, so they play very similar roles in that aspect. Those cases, no real authority has really followed on from either of those cases saying which case was right or wrong. Senior Judge Hilda commented upon that in the case of ReKL 2022, when she was looking at the question of applications of deprivation of liberties of 16 to 17-year-olds, and in that case, in respect of the REACT procedure, whether that was the most appropriate procedure to be using, and that it was found that Hilda was commenting upon it, saying that actually in reality there is still a mixed approach being taken by practitioners, local authorities, about where is the most appropriate place to be bringing the applications. And I think she, knowing her own figures, commented upon there were 4 or 5 applications per week in the Court of Protection at the time, when there were applications for deprivation of liberties for children under care orders who local authorities have parental responsibility for. But she was not able to comment on how many go to the Court of and the High Court or the Family Court to resolve issues in those proceedings. But I think that just shows that there is still a mixed view. One question I raise in respect of the Mumby point, when he was saying, look, you've got the oversight of the IRO, you've got an oversight of the children's guardian, is the question of a Rule 1.2 professional representative, whether they are able to, or a 1.2 representative of the Court of Protection, why would they not have the same sort of oversight and scrutiny as an IRO? And I think the only other point I would take from those 2 cases is when looking at it, you've got lifelong decisions about a child or a young person. I would, in my view, the most appropriate place would be the Court of Protection, because you can then have the consistency, and generally the approaches take a number of years. It's a lengthier approach, lengthier time, more oversight. There will be other points in time, and in other seminars we are hearing today about when children get to different parts, young people get to different ages, and people in the Court of Protection, transfer decisions, placement moves and so forth all have to be thought about. And I think leaving a case like that in the High Court Family Division, which will have to conclude at the age of 18, and without judicial continuity, is one reason potentially for the matter to actually start off in the Court of Protection. But we will have to see if anyone does anything about that or any other cases be brought forward. Just dealing, I think, the issues in respect to the current processes that we have is that, firstly, and I think we've touched upon it, is the question of transparency, and particularly in respect to 16 and 17-year-olds. It wasn't until the end, until very recently, that the Nuffield Family Justice Observatory started getting figures in respect of applications that are going before the Court of Protection for deprivation of liberty orders and approvals, and applications that are going in front of the National Doles Court. The figures are small because they only currently cover the 1st of April to the 31st of May 2022, and that there were 32 applications made in a period of 2 months to the Court of Protection, but 61 to the National Doles Court. At this point, I just say about transparency, there is a question, I would say, that with the Doles Court and also, in fact, applications under the Re-Ex procedure, is the question of transparency. People and professionals and parties know about what is going on, and I don't think there'll be any further transparency gained at this point in time, which is concerning. We also have the question of the lack of suitability of provision, and I will skim this briefly because Amanda is going to raise and discuss with those here the question of, is there a solution? But one of a case, and I'll give you one case which shows the concern about lack of provision, is a case from October of this year, and I think the decision only came out about 2 weeks ago. It's a case of Lancashire County Council versus X, but the judge in that case named X Claire, made her an actual person, so people understood the difficulty. She was a young person who had mental disorders, namely ADHD, had been impacted by the effect of the death of her mother, and that resulted in a deterioration in her needs, self-harming, suicidal ideation. What those in this room, I think, looking at that in part, may not believe and understand how shocking that is, because we become more used to it, because reading things like suicidal ideation, self-harm is things that we see a lot of our clients show. But the concerning part, and the thing I think shows how desperate the situation is that prior to the court getting involved, they were trying to find a secure accommodation. They could not find secure accommodation for her. There was no places available. They found a provision and had 4-to-1 supervision on this on Claire whilst in a residential placement in the Midlands. That placement said they wouldn't be able to meet the terms going forwards much longer. The High Court at that point asked, please can you? In that sense, they said yes. But after that hearing, what happened was Claire climbed on top of the roof of the conservatory in the residential unit, broke the glass and ingested the glass. And that resulted in her being taken to A&E, and that placement giving immediate notice. And what then happened, this is where the inherent jurisdiction had to be used, is the High Court judge had to allow a deprivation of liberty in an A&E department cubicle. He was asked to allow 4-to-1 authorisation in a cubicle because there's no tier 4 beds. She did not meet the criteria for CAMS tier 4. That she was placed in that provision. And what then happened was, I wind up, that's fine. I've just been told to wind up, so I will, but there's many difficulties in that case and other cases alike. But the question I'm going to pose to Amanda, who may be able to, is there a solution to this difficulty we're in?
So I think reading the Riti judgment in the Supreme Court, you can see that there's an itch that the court wants to scratch, but they can't reach it. And that's because there's an endemic problem in the organisation of secure children's accommodation. And it's this, that the sufficiency duty under Section 22G of the Children Act 1989 lies on individual local authorities. And that's a broad sufficiency duty which covers all accommodation for looked after children. By contrast, the allocation of the places is done on a national basis. So if a local authority commissions a service, they can't put first dibs on the places. The places have to be allocated nationally. And this is there's no national oversight. Since England's family judges and judges being asked to invoke the inherent jurisdiction to make doles orders in respect of children and young people, since it became that national scandal, there have been a number of increasingly intemperate descriptions of the process by all the professionals involved, and that means that there have been lots of reports commissioned. So there's lots and lots of national surveys and reports, and they all say the same thing, and that is that there are a number of reasons why the system is in meltdown and the courts are carrying the brunt of it. The first is because of what I just explained about the problem about national commissioning. There isn't the national commissioning. There should be national commissioning, and there should be oversight of the national commissioning. The second is there's not enough Tier 4 CAMS placements available in hospitals for children with young people with very severe mental health difficulties. There's not enough places. They're oversubscribed. Second is the siloing of provision of services. So you probably have come across the situation where your young person who's accommodated with CAM support reaches the age of 18, is no longer eligible for secure accommodation and therefore drops off the cliff edge because there's no transition placement available into adult mental health services, and indeed a referral to adult mental health services may or may not mean that you get any services from adult mental health services, notwithstanding that you've been found to need those by CAMS. So there's lots of siloing and complex issues. Then there's of course marketisation, which means there's not enough supply because it has the various private equity firms that have bought into secure accommodation have to make a profit, and it's a market which is inherently unsuitable for those who are in it to make money. So the whole thing is structurally unsound. And James's question to me is, what's the answer? Well, one of the things which we could be looking at as practitioners is whether we should be looking at the local authority sufficiency duty and whether there's a sufficient inquiry being undertaken about the needs of the young people in the area. So for instance, I'll give you an example. If you've got a child or young person who has capacity within the meaning of the Mental Capacity Act, is in the National Doles Court because of county lines, and there's no suitable accommodation in the area, but it's proposed to place that child in an area in which there is other risks or their support networks aren't available or what have you. So the question is, what work when commissioning accommodation for looked after young people has that local authority done about ascertaining what's the prevalence of the need for accommodation for county lines in their area? I mean, that's just an example. There are lots of sort of local government sets of guidance from the Department of Education and what have you, which local authorities are supposed to follow when commissioning. But I think it's fair to say that the issue around the extent to which the local authorities properly ask themselves the right questions when they're commissioning secure accommodation is that seems to me something which, in public law terms, we'd call it a Tameside duty. Have they asked themselves the right questions? So, I'm obviously not suggesting that everybody go rushing around judicially reviewing local authorities because they're under. But in the same way that RET provoked quite a detailed debate in the courts about what was to be done, that sort of litigation is in my view a potential seam of redress. The other question is, of course, is about what kinds of commissioning are done or unavailable. I mean, we've all come across the situation where a young person is particularly hard to place, and therefore providers aren't willing to offer that young person a place. I've even had responsible clinicians who are unhappy about supervising a young person. And so the question of risk and insurance kicks in. And again, that's got to got to do a lot of the commissioned services and provision which is available is in any event suitable to task. And I'll give you a clear example in RET. One of the clear problems about RET and the reason why a bespoke arrangement had to be formulated in a house with 2-to-1 carers put together by the local authority, and the reason why the registration couldn't catch up with the need to have that bespoke provision in place, is because there is no national step-down accommodation provision for young people who have been insecure and need to transition into restricted but not secure accommodation. And that is, obviously there's massive need for it, but that again is provision which needs to be commissioned on a national basis. The other suggestions around solutions are, I mean, James has put the liberty protection safeguards down here. I'm not sure if you had a specific observation to make about those, James. You've got the advantage of me if you have. But obviously, all these suggestions are against the background of the salami slicing that local authorities are going through anyway, with a view to meeting their duties. So what's the answer? The answer, in my view, is unlikely to be one which will be successful within the current funding and resourcing environment for accommodation. That there is still going to be an ongoing need for bespoke provision, and there is going to be an ongoing need for the system of regulation, the system of oversight, to accommodate the fact that the child's need for the bespoke provision is going to come up necessarily before. If there's no off-the-peg solution for that child, then the system of oversight is going to have to accommodate the fact that the bespoke provision is going to have to be set up and supervised before it's registered, and that will need a change to the law. Anyway, for all those reasons, no punchy answers, I'm afraid, but lots of suggestions about potential public law routes to doing that change.
Can I ask you a quick question? And that is in terms of the sufficiency duty. Is that a target duty, or is that a duty that is easily challengeable?
The actual duty itself is a due regard type duty, so it's not hard and fast. But nevertheless, if you go to court, and in fact the government said this, Department of Education said this in RET, if you go to court complaining about the national government is doing nothing, they say, well, Parliament has provided that the sufficiency duty lies on local authorities. I mean, that's the Department of Education standard response. So I think that certainly the way that courts have construed it thus far, it's a duty which has a duty of inquiry attached. I don't think that it's possible to escape. Plus, there's lots of Department of Education guidance about the commissioning process. It's like all marketisation regimes which are imposed, best value for money, which are imposed on local government. Central government comes along and tells them what their money-saving obligations are. Doesn't say a great deal about the quality or the monitoring of the service or the compliance with other duties.
So basically, it's nothing to do with us, Gov.
It's buck passing. No, absolutely. But as I say, I think it's only a matter of time before the Supreme Court looks at the RET situation again. And if the President's guidance was what swayed it for the legality of the scheme, I mean, there's also, I suppose, the question of the hierarchy of duties. And essentially, I paraphrase, and I'm sure I'm putting this crudely, but Lord Stevens at least was persuaded that if you've got an Article 3 risk to a child, Article 5 falls into the background, and you get that Article 3 risk met. And that means putting the child in an unregulated placement. That's what it means, and the system permits that. The local authority isn't acting unlawfully if it does so. But apart from that sort of justification, it's not going to be the case in all cases. It'll just be a straightforward best interest question. It won't necessarily involve Article 3, although they do. And if the President's guidance is now, well, we're not going to do that job for you, then it seems to me inevitable it's going to come back up. That compliance with Article 5 is going to come back to court.
Yeah, I think we're going to stop there because...
Unless there's any questions. Does anybody have questions?
Is there any questions or anyone online?
I can see one question from the audience.
It was just about your Article 3 point, and so for example in Claire's case and in the JS case, I think at one point where she was having like 10-to-1 restraint being kept in that setting, and I was thinking, when you start thinking about your absolute rights in Article 3, do you think we're reaching a point where that might be the best way to go with an Article 3 claim, to find somewhere else for these young people that are stuck in?
Well, I mean, yes, it's always going to be a balance of harm, isn't it? But if you've reached the stage where the bespoke arrangements are themselves doing harm, an Article 3 risk, then yes. And I think that underlines the point about Tier 4 CAMS provision.
One of the I've been doing a lot of work with the Maudsley, the Tier 4 service at the Maudsley, and what they're telling me is that they are increasingly having young people coming in who are needing Tier 4 services as a result of the trauma they've experienced in the dolls provision, and that is becoming a bigger and bigger problem for them.
And if people want to read the Clare case, there is a section within it when they've got the Tier 4 individual from, I now forget which CAMS unit, coming on and gives evidence, and he's got the evidence of his evidence within that. Well, the only other point that I was going to touch upon is that the High Court judges are getting more and more fed up, I would probably put it, in the situation you've got. If anyone reads The Guardian, there was a case for Mrs. Justice Leven publicising that about a 14-year-old, I think it was, 16-year-old was placed into a number of Airbnbs over a period of 12 months. That's the solution, and she's not very happy with it, because I think they didn't bring it to the court's attention. There's a number of those cases still going on, and there was a case, and just touching again, there's an NHS case when a trust brought a case for deprivation of liberty, and in that case McDonald J refused and told the local authority to issue proceedings, because the local authority should have issued proceedings, and that was the solution he came up with in that case, and came up with a better solution because there are not better outcomes, because they're all pretty unhelpful and doesn't really fix the situation, is that there's more duties placed upon local authorities if there are care proceedings issued than a child is kind of floating between the two. So I think in one sense it's getting more and more of the cases published is probably the solution, and then finding someone who's actually particularly interested in it, and in that sense, because there's so much of it going on, and you read the judgments now, the judges going, we see this all the time, people don't understand, or we do, general public don't understand what's going on, and I think that's also part of the problem. But we're around all that.
Yeah, just to say, my dream scenario is that a load of local authorities gang up on central government and put it out that way. But they never will.
We had that a bit.
Yeah, that's true.
And just so everyone online is, what will happen is we're going to have we will have the breakout sessions in chambers when we'll go into 2 different rooms. There will also be breakout rooms online. I've just seen the information put in. We'll put breakout rooms online for those to join those sessions and remotely. So thank you.
Welcome to the afternoon's breakout session on housing issues in the Court of Protection. 2 speakers, myself, Angharad Monk, and Dr. Tilden Baldwin. Essentially what we're hoping to do in this session is to explore a little bit of the areas of crossover between housing practice and Court of Protection work. I can see that there's at least a few housing practitioners out there in the room today, and I think certainly my part of this presentation will be probably quite basic on the housing front. So what we're hoping to do is to just identify, first of all, some of the very basics of issues about tenure that may be relevant to Court of Protection practitioners who are dealing with protected parties who have tenancies, to identify some of the areas in which housing practice can give rise to need to apply to the Court of Protection. And once we've done that, I'll be handing over to Tim to explore in a little bit more detail exactly what protection can do in the context of housing issues. And what we're hoping is that will be helpful for both sides of the practice and for cross practitioners. So first of all, why are we talking about possession proceedings at all? This is from the perspective of court protection practitioners in the room. First of all, I'm sure you'll all be aware there'll be many occasions where you're representing a protected party, and one of the issues that may be relevant to the court protection matter are the fact that they've got some form of tenancy rights. And you need to understand those to a certain degree in order to conduct proper options analyses for court protection work. Secondly, the protected party might be facing the loss of their home, and there may be issues in relation to that require the Court of Protection's input, and Tim will be talking a little bit about exactly what kind of input the Court of Protection can have in those circumstances. And connectedly to that, there may be circumstances where it's actually not realistically possible to maintain an existing tenancy, but the Court of Protection's input is required in order to make sure that there is alternative available accommodation for the relevant party. So I'm just going to, and this is the part which I'm afraid if you're a housing practitioner will probably be a little bit basic, but I'm just going to do a quick run through of some of the common tenure types that you might come across. First of all, you have private sector assured short hold tenancies, which will usually be for a fixed term, and at the end of any fixed term, they will become essentially rolling or periodic tenancies by operation of the Housing Act 1988. These, as you're probably well aware, have very minimal protection from eviction, in that essentially a landlord can use the Section 21 procedure and do a no-fault eviction after the end of any fixed term. These tenancies will usually have a market rent. You have secure social tenancies, which under the Housing Act 1985, these will usually be with a local authority landlord, but you might also see them for some older housing association tenancies which commenced before 1989. Mostly these will be lifetime tenancies that essentially will continue until they're ended through a possession action brought on specific grounds. But sometimes you might also see fixed-term introductory tenancies, which are supposed to essentially lead into a lifetime tenancy after their expiry, unless there's been any issues. And those will be at a social rent. Then we will have assured social tenancies, which are also under the Housing Act 1988, but essentially the difference is that you'll have a housing association landlord. Often will be also lifetime periodic, but it is now possible for them to also be fixed term. But it is not as simple for a social landlord, so a housing association, to simply seek possession after the end of the fixed term. And usually one can expect, in the absence of any issues, for a re-grant of another tenancy, and there will be policies relating to that. And special procedures that need to be carried out if they do want to bring a tenancy to an end at the end of the fixed term. So it still does have more protection, considerably more protection than a private AST. A little bit less common, you might also see protected or regulated tenancies in the private sector. And essentially these are any kind of private sector tenancy that began before the 15th of January 1989. And those are becoming quite a rare beast, but they are essentially lifetime tenancies as well that have very strong protections. So it's important to identify them if you do come across one, because it's certainly worth putting up a fight to save a tenancy if it has the protection of the Rent Act 1977. They are rent controlled, and they have succession rights as well, succession falls a little bit outside the scope of the presentations today, but we can have a chat about that if anyone wants to after the sessions. So essentially all of those tenancies that we've discussed have what's called protection from eviction, meaning that you can't evict a tenant without a court order, and essentially the court will need to see that grounds of possession have been made out in order to make a possession order usually. And there's quite a lot of different grounds. We're not going to go through all of them. The key difference to note is whether they're discretionary or mandatory. And as it sounds, essentially discretionary means that the court has to be satisfied both that whatever the circumstance of the ground is made out, but also that it's reasonable to make a possession order. So that leaves you with quite a lot that you can say in terms of preventing a possession order. Or mandatory, which is a ground which essentially requires that the court make a possession order if the relevant circumstance has taken place. I've included this slide just for your information, and you'll be sent it after this conference, but this is just to highlight where all of the different grounds that apply to the different tenancies can be found. The shelter website has a really helpful summary of all of the different grounds for possession if you're ever in any doubt. There are some other situations in which possession actions can be brought without statutory grounds being relied upon, and that will be where the security of tenure applicable to any one of these tenancies has been lost, usually because either the tenant has died, in which case you need to look at whether there's any other occupant that might be entitled to succeed, or that they've lost their security of tenure because they've ceased to occupy the property as their only or principal home, which can be an issue that comes up in the COP, because obviously you may have situations where people have been placed into a care home and they have a residual tenancy. So basically, we're just going to have a little think about some of the common possession claims that do have a degree of overlap with the Court of Protection. This is purely coming from my own practice, which is primarily as a housing practitioner, situations where we do often come across clients that lack capacity in various respects. Rent arrears issues. Rent arrears possession claims can be brought on both discretionary or mandatory grounds. Only local authority secure tenants are safe from mandatory grounds, unfortunately. It's worth noting that with a social landlord, whether that's housing association or a local authority, they do need to comply with the pre-action protocol for possession by social landlords, which essentially just mandates that they engage in various pre-action steps to try and resolve the arrears. We will often see that very little is done in reality. Mandatory grounds is basically a situation where there's over 8 weeks, or in the case of a monthly tenancy, 2 months of rent arrears at the date of both the notice of seeking possession and the possession hearing. One of the reasons there's crossover here is because, quite obviously, if somebody lacks capacity to deal with their financial affairs, there's a whole array of situations in which that can result in arrears accruing at a property and can put their tenancy at risk. Then antisocial behaviour is also a very common context in which we come across incapacitous clients. Again, this is both discretionary and mandatory, and the mandatory grounds can be relied on by any landlord, both local authorities and housing associations and private landlords. And the mandatory ground is based essentially on certain other orders that might already have been obtained, either in a criminal or injunction context, or a closure order having been made in respect to the premises. There are also discretionary grounds, and usually what is said is either or both, usually both, that the person has breached their tenancy terms, because there will almost always be a tenancy term relating to various different kinds of behaviour, or that the statutory antisocial behaviour ground is made out. I haven't cited all of those grounds, be able to look them up if you need to, but usually in cases where what's alleged is connected to incapacity, I find that usually there is pretty strong evidence that the conduct is antisocial and that it has taken place. The issue will be around whether that person actually has capacity to comply with their tenancy, and what links there may be between the behaviour and the incapacity, but also there may be a disability discrimination element as well, even if it's not quite reached the level of incapacity. Hoarding, I've put as its own topic, because this is probably the most frequent, certainly from my practice, of cases where it can end up being necessitating an application to the Court of Protection, and this is usually brought on discretionary grounds relating to the breach of tenancy, or there's a specific statutory ground in respect of the deterioration of the property. And it is possible to sometimes see antisocial behaviour being pleaded as well, where the impact of that behaviour is going beyond the home and is actually impacting on others as well. These cases tend to be some of the most complex and sensitive in housing practice, and often tenants that have severe hoarding issues are going to have mental health diagnoses, and possession proceedings will often raise the whole gamut of capacity issues. They may lack litigation capacity, or they may not. They may lack capacity over their hoarding behaviour itself, and essentially you tend to quite quickly hit roadblocks with resolving the issues if there are capacity issues in respect of the hoarding, because as we'll discuss, there are limits to what the litigation friend can do in the context of the possession proceedings themselves. When do we need to make an application to the Court of Protection? and how can it help? In the context of rent arrears, in the context of all of the cases that I've discussed, there is often a direct link between the lack of capacity and the grounds for possession. So what will happen is if the protected party, if there is no COP application and the protected party is being represented in the possession proceedings, they may or may not lack litigation capacity, in which case obviously they will need to have a litigation friend. Basically, often the first thing that's going to be identified if the person doesn't yet have a live court of protection case is the issue of litigation capacity, because that will be raised at an early stage. And then what will happen is if there's a litigation friend put in place, the housing lawyers will look to defend the possession proceedings, and that will usually be either on the basis that a possession order is not reasonable, if there's discretionary grounds being pleaded, or if there's mandatory grounds, there may also be public law or disability discrimination defences. But ultimately, everything comes down to the ultimate question of what can be done as an alternative to this person losing their home. And in situations where it goes beyond a lack of litigation capacity, as often it will do, you quickly will hit roadblocks, because if the person, if for instance, it's just not viable to keep somebody in their home and they've got support needs that require perhaps a different kind of accommodation and you need to do a managed move, if they don't have capacity to either make decisions about their place of residence or to perhaps surrender or enter into tenancy agreements, then you're just not going to be able to affect that, which is probably realistically, in many cases, the only possible way that you can prevent somebody's homelessness in the context of these proceedings, if there is no other solution to the ongoing problem, and there's either a danger to the person themselves or possibly their neighbours as well. So at that point, it will often be necessary to make an application to the Court of Protection. And Tim is going to talk a little bit more about all the different things that the Court of Protection can do. Just a couple of practical points from my perspective, and this is a tip that I actually took from Tim as well, is that if you have got both possession proceedings and Court of Protection case, you can actually ask the courts to try and list them together. A lot of district judges and circuit judges will have both tickets, and it can be really, really helpful to get the holistic perspective on both of the matters together, because they will often be very intertwined. My view is also that if you do have these two competing cases and they're both looking at the same subject matter, it's usually appropriate for the possession proceedings to be the one that stayed for the determination of the substantive matters in the COP. And that's basically because, as I said, you hit a roadblock with how much can practically be achieved through the possession proceedings because of the fact that the person may lack capacity in respect of matters that are necessary to progress a sort of practical solution. And until the COP has sort of done its job in that respect, it's difficult for the county court to make a decision on reasonableness or proportionality in a disability discrimination issue. I suppose just one final note from me before I hand over to Tim is that outside of the context of possession proceedings, if you've got, I think it's really important if you've got a protected party that you think there might be underlying tenancy issues or even the possibility that possession proceedings are going to be brought against them, it is really important to make sure that they've got representation in that respect from an early stage, and not to just sort of take it as a given that if proceedings have been brought that the home will be lost, because there is a lot that can be done to preserve that, whether it's preserving it as an option or whether it's already been determined that is the person's best interests. Essentially, just flagging to ensure that they've got representation on both fronts. And Tim is now going to talk a little bit more in depth about what the Court of Protection can do in this context.
For those of you who are housing practitioners, you will be well aware of a thing called the White Book, 2 volumes. If you're dipping your toe into Court of Protection practice, there's a purple book. So that wraps up pretty much the legislation, the guidance, practice directions, some discussion about cases. So there is one like this, and it's such an old-fashioned arrangement that it does have a CD in it. So it's that sort of arrangement. So what I'm going to try and talk about is really how can the Court of Protection help you in your housing case. Because we have, for example, the Central London County Court there the Clerkenwell and Shoreditch County Court over there, which I ran back from today in the rain, and we have the Court of Protection on First Avenue House there. Angharad helpfully said that it's useful sometimes to have the same judge doing the same case in two different jurisdictions. That's often can be achieved in out of London county courts, but unfortunately it's very difficult to achieve that in central London, even though they're very close, unless you can persuade judges like His Honour Judge Beckley to migrate with his entourage down the road and sit as both a judge of the Central London County Court and Court of Protection. But unfortunately, that doesn't happen. So how can a Court of Protection help? How can a Court of Protection help? What can they achieve? Why is having a litigation friend not enough? Those are the real issues here. And in possession proceedings where, as Angharad said, there's often issues about paying rent. There can be welfare benefit issues that go maybe beyond the ability to have appointees who deal with the Department of Work and Pensions. And there are antisocial behaviour and hoarding cases, and I've given you an example there, and injunctions. Ideally, when you look at the pre-action protocol for social landlords, it flags up issues of does the tenant have capacity? Should there be an assessment of their care needs? Should you refer them to benefit advice? That's all there for social landlords, which are largely ignored. But it's all flagged up, it's all there. For private landlords, no, there's really no requirement to engage with those things. Also linked with everything are injunction and enforcement of those. Those can often involve someone who lacks capacity. And also, so you've got all those issues related to that. And the litigation friend is only appointed when somebody lacks capacity to help somebody with the litigation. Their remit is quite narrow. They can progress the litigation, they can end the litigation by settling it. But if there are ancillary things, such as do you need somebody to help with the rent payment? Do you need somebody to apply for welfare benefits? The litigation friend within that role cannot deal with that issue. And the reason why they can't deal with that issue is the issue of capacity is issue specific. And I'll come to that when we have a look at the legislation. Also, if someone's going to be evicted or if somebody is homeless, how do you make applications for accommodation under Part 6 and Part 7? They may not have a capacity to make that application or enter into a tenancy agreement. That's a separate issue from what a litigation friend can deal with. And also specialist forms of accommodation. Do they need supported living? Do they need residential care? Also, discharge from hospital or detention psychiatric hospital. What sort of accommodation will they need then? And there are particular parts of the Mental Capacity Act that deal with when somebody's in care home or need specialist forms of accommodation and support. So how can the Court of Protection help you if you're a housing lawyer and you have this incredibly complicated case? You look at it and you go, this is not the game I wanted to get into. This is a bit more than is beyond my pay grade. How do we deal with that? How do we resolve that? Because you will have your housing contract from the legal aid agency and look at it, and it doesn't mention Court of Protection work in that. It doesn't mention it. You have to go to maybe someone with a community care contract or mental health contract. How can I get the best outcome for my client? And also, there's clear interaction with adults. The Care Act. You need assessments. You need local authority intervention. You need all sorts of things going on to defend your possession claim or secure accommodation for your client. And also you need mechanisms of sharing evidence between the two jurisdictions. You can't just turn get a bundle from His Honour Judge Luber's office and take it along to His Honour Judge Beckley just along the road. You have to get specific orders about interaction of disclosure of evidence between the jurisdictions. So there's a whole lot of things that can go on, but the Court of Protection can really help you. And the invoking the jurisdiction of the Court of Protection, the Mental Capacity Act itself is an act which is effectively a codification of the previous common law. There's nothing new, nothing novel in any of the principles within it. It's just a formal codification of that. And Section 48 of the Act is very, very useful because what it does is it creates the jurisdiction for you and it allows the court to make interim orders. And all that you have to have is some reason to believe that someone lacks capacity. That creates the jurisdiction. Not that they do lack capacity, not that it's definite, but some reason to believe. So a low threshold that creates a jurisdiction. And that can be capacity in different issues. Capacity to litigate, capacity to manage their property and affairs, capacity to make decisions as to where to live, capacity to make decisions as to where to reside and receive care, capacity who to have contact with. And particularly in personal welfare applications, which is what issues around housing, homelessness are, Section 50, subsection 2, requires permission. So you make the application, the court gives you permission. And all you need is a very low threshold. You just need some basic ground of lack capacity, what the issue is upon which the person lacks capacity. And the reason why no one else apart from me seems to chunter on about this to the county court is that Section 47 of the Mental Capacity Act empowers and creates a High Court jurisdiction. So formally, the Court of Protection is the High Court, whereas, as I said to His Honour Judge Lube on occasion, you're merely a puny judge. That's a lower court. So it should take precedence over the county court once it's engaged. And Section 15 of the Act, that creates power to make declarations, and that can be linked to the Section 48 and the rules of the Act to make interim declarations. And Section 16 of the Act creates a power to appoint deputies for personal welfare, property and affairs matters, and also enables the court to make orders. And that link with Section 47 allows it to make injunctions. And in respect of the various other sections, you can see linking Section 17 to 16, the personal welfare, so the court can decide where someone is to live, and can also deal with care and contact. And 18 and 16 deals with property and affairs. And Section 7 in particular deals with payment for necessary goods and services. So that's linking it to payments of benefits and rent. And that the court can empower somebody to do that on behalf of the incapacitated person. And Section 20 also enables the appointment of a lasting power of attorney. One thing that is often overlooked, both in the county court possession proceedings, in homelessness applications, is whether this person has appointed a power of attorney, someone who can make decisions on their behalf if they become incapacitated. So that's basically what the court can do. It can make all sorts of orders, all sorts of declarations. It has a jurisdiction that's engaged where there's just some reason to believe, some evidence that somebody lacks capacity, and away you go. The basic principles, it's always useful to look at the basic principles under the Mental Capacity Act. And basically, this act applies to people over the age of 16. And the touchstone is always whether or not they lack capacity to make particular decisions. And the presumption is that they have capacity unless they lack it. A person's not to be treated as unable to make decisions or practical steps to help them. And they've been unsuccessful. A person is not to be treated as unable to make a decision merely because he makes an unwise decision. You may feel at the end of today that it was an unwise decision to come to this conference. That does not necessarily mean that you lack capacity to make that decision. And an act done or a decision made, and this is a key element of the principle, an act done or decision made under this act for or on behalf of a person who lacks capacity must be done or made in his or her best interests. So what it does is it creates a jurisdiction whereby if you establish someone who lacks capacity, then there can be substituted decision making in respect of what their best interests are, what the outcome is for them in terms of, say, their future accommodation or remaining in accommodation. And it must, in 6, it says, the less restrictive of a person's rights and freedoms. So as Angharad said, in terms of looking at this issue, if someone lacks capacity, but in respect of a decision in respect of continuing their present accommodation, the court could make an order saying, well, we've now got this care package, and with that, we consider it's in his best interest with this care package to remain where he is, because that's a least restrictive option. Then what does the county court do if you've got a court of protection order saying that? The question would be, can the county court then evict? I don't think it can, but you'd have to take that up with a county court judge. So it's a principle in there that even though someone lacks capacity, you make a best interest decision on their behalf. It has to be the least restrictive one. People who lack capacity, that's under 2. And the key things here are capacity in relation to a matter, if at a material time unable to make a decision of himself in relation to the matter because of an impairment or disturbance of the mind. Now, there are a couple of key things here that always must be taken into account. That is, lacks capacity in relation to a matter. So that's an issue specific thing. You have to have, if they have different decisions to make, there has to be an assessment of whether they lack capacity in respect of those different elements. You can't say just because they lack capacity to litigate, they lack capacity to make decisions where to live. Those don't necessarily equate. And they're unable to make a decision at a particular time. So it's time related. And it arises because of a matter of impairment or disturbances of function of mind or brain. This is a different test to that under the Mental Health Act, which is a mental disorder. Formally, to engage with this jurisdiction, you do not need a diagnosis of a mental disorder. You just need evidence of a disturbance, impairment of functioning of mind or brain. And sometimes that's where the courts have gone wrong when looking at hoarding cases. Formally, in English law, hoarding is not identified as a mental disorder within the meaning of the Mental Health Act. There is no formal diagnosis of that. But it's a disorder of the mind and brain that can impair decision making. It says it doesn't have to be permanent, it can be temporary, and there are all these various things that you have to consider. And Section 3 of the Act also identifies the tests to apply once you have somebody you think lacks capacity. And there are the various tests there under 1A. Often the key test is the inability to weigh or use information in respect of the decision making. It has to be the relevant information. For example, can somebody understand the terms of the tenancy? Can they understand that they need to pay rent? And there are the elements there that have to be met. One of the key elements that's often missed is Section 3.4. And that has to be information. This is really annoying. Information relevant decision includes information about reasonably foreseeable consequences for deciding one way or another. You often see capacity assessments missing that. So what if you make this decision, do you really understand the consequences of what you're doing? Or even failing to make the decision, does that affect your ability to make a decision. So it's a functional test. We look at the ability of someone's functioning, and then a diagnostic test. It's helpful to have a formal mental health diagnosis because through treatment, you may go back to the first principle and they may be able to recover capacity to make the decision. And so that's always something, if you have it, it's useful. But Section 4 of the Act sets out the issues in respect of then deciding on what their best interests are. And I've summarised it in those bullet points for you. And the other sources are particularly the Court of Protection rules and also the rules on independent experts. In order to get a thorough assessment of someone's capacity, you'll either have to get a court-appointed expert under what's called the Section 49 visitors procedure, or if it's particularly complex, an independent expert, and the rules of the Court of Protection deal with that. There's a code of practice, and the relevant sections for your practice would be chapters 4 on capacity and chapters 5 on best interests. And there's further useful NICE guidance that is in the link there. So what do we do? How can COP help tenancy and license? If someone, notably a landlord, has evidence that a person lacks mental capacity when it comes to a tenancy, entering into a tenancy, they cannot enter tenancy agreement, assign, vary a tenancy, or end the tenancy. And it can be that the tenant, during the currency of the tenancy, then lacks capacity. And the ability to contract is a common law ability. You can have tenancies in equity. We've avoided the complex relationships with succession, but there are cases that deal with minors and succession. And those tenancies are tenancies in equity where the legal owner is either the local authority or a third party holding it on trust for the minor. There's been no real developed case law in respect of adults. And even the case law involving minors is somewhat controversial because of the vesting provision, because the tenancy does not vest in the person under the statute. So it's all a bit of a hoo-ha, whatever. So if someone lacks capacity, you need someone to act on their behalf. That is either to enter into the tenancy, end it, vary, assign it, or whatever. And you can get a court-appointed deputy. The Court of Protection can appoint either an interim deputy or a final deputy to deal with that issue, or look for someone with lasting powers of attorney to deal with it, or an order of the court can make a provision to enter, assign, vary, or end a tenancy. And the court order itself can identify some named person to deal with these issues. This can be important in particular because I've got the learned Mr. Rutledge in the front row studying this in detail in terms of applications for welfare benefits. And that relates to the Section 17 powers. With the DWP, you can have appointees. You can get an appointee there. But sometimes the issues in respect of the management and payment and securing benefits and making payments under the tenancy and entering into tenancies or renewing them can require a more complicated arrangement. And there is the old Whiteshaven District Council case that I've identified within the slides as to holding somebody liable to pay housing benefit, even though the tenancy agreement was annulled. So you need somebody to do that for you. And what can finance deputies do? Part 21 of the Civil Procedure Rules govern what a litigation friend can do, and that is limited to capacity to conduct litigation. That's one issue. But they cannot make applications of benefits, cannot sign new tenancy agreements, cannot agree to directly terminate tenancies, may be able to make application for the Court of Protection, and surely can do. And also Part 21 includes compromise of litigation. You have to make a distinction between protected parties and protected beneficiaries. Some people don't have capacity to litigate, but have capacity to manage their finances. Some people lack capacity for both. A protected beneficiary is somebody, for example, receiving damages as a result of a possession matter. That is a separate procedure. But everything else may require a deputy. You can get urgent interim applications for benefits and payments of rent, appoint a deputy or panel deputy or a deputy with a local authority to manage a tenant's property and affairs. In reality, this should all occur within the pre-action protocol procedure. But in the real world, it doesn't. No one is really grappling with that. And a deputy's power may be limited by court order in respect of consultation of a litigation with a litigation friend. For example, if it's determined that it's in the tenant's best interest to end a tenancy, a deputy has generally untrammeled powers to do that when they're appointed under a standard deputyship. But the litigation friend, by way of court order, you can have a situation where the court directs that the deputy has to consult with the litigation friend before that. You have to engage always with the tenant's best interest. And also what can then happen is, well, if somebody is evicted, somebody no longer has their tenancy available to them, what do you do? How do you apply for housing? How do you apply for specialist housing, residential care and supported living? How does this work? And how does the Court of Protection help you? And this has always been a conundrum of mine. I've always wondered how this works. If someone is when you find somebody intentionally homeless, everyone's aware of that. And the guidance at 9.17E, the Code of Guidance, says a housing authority has reason to believe the applicant is incapable of managing their affairs, for example, by reason of age, mental illness or disability. So the Code of Guidance makes this strange situation where someone can't be found intentionally homeless if they have reason to believe they is incapable of managing their affairs. But the problem is they can't make an application as homeless. So how do you get to this assessment? How do you square this circle? And also, it says an act or omission was a result of limited mental capacity or temporary aberration. Within the statute, there's no such thing as limited mental capacity. What do they mean by that? So the way that the guidance is formulated in terms of intentional homelessness doesn't square easily with the person's inability to make an application for homelessness assistance. So that's all well and good. So how do you get there? Capacity and homelessness applications, the leading cases are still Tower Hamlets and Furdus Begum. These are pre-Housing Act 1996 cases, pre-MCA cases, and it involved those young men, David Watkinson and Leslie Thomas, representing Furdus Begum. There's also a case of Garland. But it is the responsibility of the local authority to decide whether the applicant has capacity to make a homeless application or not. It is a specific issue. Local authority officers are professionals. They're identified under section 42.4c specifically, that they have to make that decision. You can have advocates who help you, but formally, you cannot make a homelessness application even if it's likely that you would be in priority need, not intentionally homeless. Formally, you can't even access interim accommodation under 1881 because you can't make the application, you can't get into the system. So was Furdus Baker good law, given that it was pre-MCA, pre-Care Act, Furdus Bacon considered alternative accommodation in Section 21 National Assistance Act. There was also consideration in the context of a child, different sort of capacity issue, nothing to do with mental disturbance. The Court of Appeal in WB confirmed Furdus Bacon was good law, even though you had all these changes in legislation. Also, in the other case, Garlick, they identified, well, if you had a deputy or an attorney, it could do it on your behalf. So the question in WB is, well, how did all of this comply with the Human Rights Act? So how do we get around these conundrums? Especially if you have care and support, you need specialist accommodation. Well, what they ended up saying is, well, you can always appoint a deputy. So you can always go to the Court of Protection and make an application for a deputy who can sign a tenancy agreement on your behalf and make the application for you. Is this really ideal, given the timescales? And if you look at the order in WB versus W, you can see at the end there's an order from the Court of Protection that suggests that in the interim, if there's a dispute on capacity that can be resolved within the Court of Protection, because the Court of Protection can determine whether someone has capacity on this issue or not, there's a suggestion in the interim, the Court of Protection can order that the local authority provide accommodation under Section 16 of the Mental Capacity Act. Also, if you're engaging in a Care Act assessment, 19.3 of the Care Act can provide accommodation there. There's no issue about capacity there. So that is the way around it, that this can also lead to applications under Part 6, and also the Court of Protection, in very complicated cases, can look at options for specialist alternative accommodation, such as supported living or residential care. It may be that when your client goes through various assessments, the Court of Protection is presented with different options: going home with a care package, going into supported living, a care package going into residential care. The Court of Protection, in resolving your case, because you've got cases involving someone who has antisocial behaviour problems, people who are behind in rent, can't manage their tenancies, the Court of Protection can, if presented with options, look at alternative provision. That is its power. And that resolves cases, for example, antisocial behaviour, can't understand the terms of the tenancy, can't understand the terms of injunction, they're walking incompetent. What do? You can get all that dealt with in some way, but you're likely still to end up with a possession order. You might store things out. So how do you resolve it? Well, the Court of Protection can provide you with the answer, and it can provide you with an answer to how to make a homelessness application where the least restrictive option may be mainstream accommodation with a little bit of care and support. Just to finish with, there are different jurisdictions, there are particular rules about transparency and identity within the Court of Protection. There's something called a transparency order. If you want to disclose evidence in the Court of Protection into the county court, you have to get an order and permission. If you do that, you'll also have to make an application for anonymity and non-disclosure of those documents within the county court. Likewise, if you want to put county court or family court evidence into the Court of Protection, you have to get a similar order. So that, in a nutshell, in a real trot, and consolidating this book into about 30 minutes, that's how you can try and use the Court of Protection, the county court, together to resolve your housing cases. So thank you. We are due to have another break, but if people want to ask any questions, we're happy to try and answer them.
Let you come and sit down, please.
Yeah.
Can I ask just a couple of quick questions?
Yeah.
And thank you very much, both of you. That's really, really helpful. We've got a similar case to the one where we've got possession ASB, client has paranoid schizophrenia. We're not sure how to resolve it without the court protect. I think we will have to go. We've got this official solicitor as litigation friend. Would the official solicitor be at cost risk if we went to the court protection? I'm not sure how it works.
No. The official solicitor it's a different bit of the official solicitor. They can operate within a court of protection. Often they'll either want an undertaking or an investigation as to the person's means to get a legal aid certificate. But the court of protection operates basically on a no order as to no cost jurisdiction. And that's a standard rule. So there is no cost risk in respect of an application to the court of protection, save for if you do something completely unreasonable or beyond your proper scope as a litigation friend within the court of protection.
Yeah, great, thank you. Can I ask another couple of quick questions? Yeah. When you were talking in the slides about a local authority being deputy, is that where the opponent is a local authority? If you're against a housing association?
Yeah, very rarely would you there would be no deputy service within a housing association. But what can happen is some local authorities have a particular division. Sometimes they're called their appointee team or their deputy team. So you have an identified social worker who can undertake that role that's separate from, say, the housing officer or the housing team, who has a specific role within the social services department to act as a deputy. Sometimes they don't want to do it if it's very complicated. If they don't want to do it, then the court has the power to appoint a panel deputy if there's no family member. And that's an identified list of authorised solicitors with fixed fees to do that. And sometimes you can get the local authority to fund the panel deputy to make decisions on, particularly in respect of finances. That's where it really lies. The finances to enable your tenant to pay their rent or pay any charges.
Yeah, great, thank you. And finally, where there's conflict, so we have assessed our client as a psychiatrist has assessed her as lacking capacity, but the social worker involved thinks she has capacity to do other things, and we've had this on other cases. It's just not clear.
You've got a dispute, and that's the point of the court of protection. It's there to resolve disputes. Within the court of protection, under section 49, there's a visitor provision, and that visitor can also include the appointment of a psychiatrist to do assessments of capacity to litigate, capacity to receive care, capacity to live, where to live, things like that. And the court itself makes an order directing that person examine, inspects records, and produces a report. So if you have a dispute over capacity, that one side says capacitus, other side says incapacitus on these particular issues, then there's a mechanism within the court to use that, or if it's incredibly complex, to go through joint instruction of an independent expert. So you get evidence, you get independent evidence that way. And the court is not going to say, well, I just prefer A's, the local authorities' case over B's, unless unless one side is just completely ridiculous. It is for the court to decide. But if there's a dispute, often the court will go down this route of appointing what's called a Section 49 visitor or an independent expert to help it resolve these issues. Because the court of protection operates more as an inquisitorial jurisdiction. Everyone is supposed to focus on the best interest of the protected party. It's not supposed to be adversarial. It's supposed to be cooperative. It's supposed to resolve this issue in a non-adversarial way.
I have a question. We have a case at the minute.
Sorry, I can't hear because of Sounds like James Holmes yammering on outside.
We have a case at the moment where the tenant, secure tenant, is unable to stay at her home, so she's now placed in a care home. However, we have the adult son in the home who's resided there for 20, 30 years.
Yeah.
How do we assign the tenancy to the son?
By appointment of a deputy with the power to assign.
Can the son be the deputy?
Son, the problem with that situation, because there's an arguable conflict of interest, that it shouldn't be the son. It can be. It can be with the local authority because they've got a vested interest in it. It could be through social services if it's deemed in the best interest, but also the court could make an order. The court, in theory, could make an order without appointing a deputy to assign the tenancy. But it's probably better for the court to identify a deputy to be that financial deputy.
I would have thought you want to do that quickly because there's a risk of.
Yeah, and also what you want to do is you can get an interim deputy put in place to deal with that really quickly. And it may be that you can also seek an order from the court stopping the possession proceedings.
Thank you.
I'm assuming is there a fast track to making these interim orders if there's some sort of emergency?
Yeah.
Can you do this kind of work under a housing legal aid contract? Sorry, I don't know if
I don't think so. It might be to do it if I don't know if there's still some slippage, if it's related. I've known people who do it in public law contracts where, for example, an education issue where there's a COP issue related. I feel it's very difficult. Often what you do need is if you have a firm or a link to a firm with a community care contract, you'll probably have to go down that route because it's going to be more involved because you might end up having to challenge the needs assessment by way of judicial review. You can't really challenge that within the Court of Protection. The Court of Protection merely authorises or pulls faces about it. They can't formally quash it. So ideally, you'd either want a community care or mental health contract because those contracts have specific provisions in them that allow for this work.
Yeah, that's certainly been how I've done it when I've had solicitors who've just had a housing contract. Is you just do a referral because then you can deal with any Comcare issues that arise as well.
that's really helpful. Thank you.
I'm going to come to Desmond in a moment. Was there somebody else behind Desmond? I saw a hand.
No, it's the same question about the contracts.
Okay, Desmond, what's your question?
Both talks have mentioned that someone in the housing county court defending possession proceedings where there is capacity issues and a litigant friend, they will come up against some sort of blockage where they can't go any further. So I was just going to, can you think of examples where a litigant friend cannot make a decision? That is the trigger for you to think about the getting it out of the county court, despite the judge probably thinking, "Oh, I can deal with this.
Yeah,
do this every day."
The classic one is when the to rent arrears, the tenant P is entitled to welfare benefits, but they refuse to make the application. So there, the litigation friend can't do nothing in the county court.
Or managed moves is a really common one as well.
So in order to, one, at least hold the situation, for example, you've got a housing association claiming possession on large amount of rent arrears, and the reason for that is that P refuses to make an application for universal credit because they believe they're being conned by. Then what can the litigation friend do? Because the litigation friend is appointed to manage the litigation within the county court. In order to deal with that issue, either you get an appointee, or you, and which is going to be tricky and difficult within the timescale, or you do an urgent application to the Court of Protection. The local authority, if there's local authority involved in some way, shape or form, saying to local authority, look, this person needs care and attention.
That's clear cut. It's unusual for someone to refuse to claim benefits. But I was thinking of a scenario where you're defending a possession proceeding, you go through all the options and you're running out of mileage and you're thinking maybe the only thing that's on the table is some sort of suspended possession order, but you're queasy about that being agreed by a litigation friend.
Because also the question would be as well, can the tenant properly understand the terms of the tenancy? Even with a suspended order, is that maintainable in the future?
How do you know?
Well, you don't. And
there'll be a lot of pressure from the judge and whatever.
And it may be that because of that, the accommodation they're in is not suitable for their continued occupation. They need forms of specialist support elsewhere. And you want to end that tenancy. If you want to end a tenancy, all the litigation friend says, hold your hands up, make the order, judge, and not enable the provision of alternative accommodation, which is either through Care Act provision or an appointment in an action in Court of Protection for the Court of Protection to identify alternative accommodation which is suitable and which is there in that tenant's best interest. It may even be that tenant needs to be deprived of their liberty within particular forms of accommodation. It may be that serious.
Well, thanks everybody for coming. This session is on community care law and education law for lawyers. I'm going to briefly go through some nuts and bolts of Comm care. I'm really sorry because seeing lots of people in this room, I know you're very familiar with the Care Act, etc. I'll go through it really quickly. I have a more detailed presentation which I'm just going to skirt over, which is slightly oddly behind you, but you will get given the slide. So don't make notes, just sort of listen to me talk about it for about 10, 15 minutes. Susan will be speaking on education issues, particularly SEND, for about 15 minutes, and then probably the most useful bit is we're going to have an open door conversation about the practical issues that we have when these issues come up in Court of Protection practice, or when they come up in your substantive education or Comm care practice, and you're thinking, do I need to go to the Court of Protection? I think Amy will be coming back to keep an eye on it, but we can see if any questions go into the chat button up there. And so I'm going to cover in 15 minutes, or maybe less than that, the Care Act, all of it, NHS Continuing Healthcare or CHC, relevant bits of the Children Act, very briefly transferred from children's to adult care, and even more briefly, disability adaptations. But this is super, super brief, and you will get a detailed handout. So I'll come on to this later, but the starting point for the Care Act is Section 1, the Wellbeing Principle, and it underpins every aspect of the Care Act. And very often, if you bring a judicial review claim, you may be arguing a Padfield-style breach of the Care Act, that decision-making is contrary to the wellbeing and frustrates the wellbeing principle at the heart of the Care Act. So just some of the key points as to architecture around decision-making under the Care Act. The duty to assess needs for care and support is under Section 9, and it arises regardless of the local authority's view of the level of adults' resources. And there's a duty to provide a written record of that assessment. Then there has to be a decision on eligibility. That's around Section 13. The duty to meet eligible needs crystallises where a person is ordinarily resident in the local authority area or present in its area that has no settled residence, has been assessed as not liable to pay a charge, or one of three conditions in Section 18, subsection 2 to 4 are met. I'm not going to go into it in any detail. Then there's a duty to compile a care and support plan, and that's Section 24 to 25. And that's sort of the key architecture and provisions you need to be looking at if a Comm care issue is coming up and may need to go to court protection. Great, and this helpful flowchart should hopefully summarise everything. And you will have access to this at a later date. I find that most of my Comm care work is more judicial review work rather than court of protection. But obviously it comes up in the court of protection, but the nuts and bolts understanding of the Care Act is sort of sometimes subsidiary in the court of protection. Whereas actually you need to be much more familiar with the statutory provisions if you are arguing, for example, a fail to comply with statutory duty in a judicial review. But I think that's maybe an error on my part, or an error on whether we're doing court of protection stuff, to put this too much in the background, because all of the best interest decision making is premised on compliance with statutory duties and understanding this statutory framework in detail. And there are points when you may need to jump out of the court of protection and go into judicial review proceedings. For example, if a funding decision has been made which is outside of the jurisdiction of the court of protection. So having your mind focused on the statutory framework and the duties that apply, and when there may be a breach of it, it's not just don't solely think about best interest. Think about actually, has it been an unlawful decision? Is there sort of section 19 interim support required, for example? That if they're refusing to do that in the court of protection, that's a judicial review. The eligibility criteria, again, this is basic nuts and bolts stuff. You need to know it. It's going to be on the slides. You're going to have the slides. I'm not going to go through it in any detail. Important to recognise, and I think I said this at the outset, the well-being principle underpins everything. So the general duty under section 1.1 of the local authority in exercising its functions to promote individual well-being is defined in subsection 2, and to have regard for matters in subsection 1.3. It includes persons' wishes, restriction on rights and freedom of action to keep and action kept to the minimum. Needs assessments must include assessment of impact of the adult's care and support on matters specified in section 1.2, the outcomes of the adult wishes to achieve, whether and extent care and support can contribute to achieving them. That's section 9, subsection 4. The care plan must specify to which matters referred to in section 9 to subsection 4. The provision of care and support could be relevant. Now, there's also the duty to keep care and support plans under review generally, and as care and support statutory guidance makes clear that that can't be a delayed process. And one of the things that we always see in practice is, okay, it's taken forever to actually finalise a new care plan after a review. And sometimes the court of protection can be a mechanism for applying pressure. So if you're going in front of a particularly focused DJ who's going to be sort of applying pressure, putting directions into evidence that's going to compel compliance in practice, great. But actually, it's a public law error too to not be completing a care and support plan in time. So I guess what I'm saying is, don't forget judicial review as the mechanism. If you're being frustrated with endless direction after direction after direction in the court of protection and not compliant with that, remember, there are hard-edged public law principles that underpin these duties. Go out of the court of protection and jail them. Next slide. I'm not going to spend too much time on this about reviews and reassessments in any more detail, but I would flag some important points, and there's some similarities in relation to mental capacity here. The right to independent advocacy and the recognition that individuals' needs fluctuate, and that's obviously correct. We know that mental capacity fluctuates, but people's care and support needs more generally fluctuate. And that requires a sustained look at someone's care and support needs over a length of time to establish accurately the level of an individual's needs. Similar to mental capacity, someone could be making capacity decisions one day, and if you take a snapshot look at that capacity, that's not going to give you an indication of actually day-to-day functioning. So the more complex the needs and the fluctuation of the needs in terms of care and support, the more sort of holistic and lengthier the look needs to be. Other points on care and support plans, we all have undoubtedly, and I'd be really interested to hear people's views on this, had difficulties in relation to personal budgets, lack of transparency in personal budgets, including somewhat arbitrary decision making. that often does go out to the Court of Protection because it involves money, and Court of Protection can't say, look, you need to plonk more money in this personal budget. That's outside of its jurisdiction. And testing the boundary between the jurisdiction of Court of Protection and judicial review is one of the things that we'll hopefully be discussing a bit later. Carers, assessment and care planning duties, I put them on a screen. It's good to have them to hand. They do come up in Court of Protection practice relatively frequently. Good to understand that underlying statutory and regulatory framework. And in terms of Care Act 2014, remember that there are powers as well as duties, and it sounds like it was basic public law 101, but actually there's an underlying power in section 19, even if you're not assessed, to provide interim support, and that has to link back, when you've got power, to the underlying statutory purpose of the scheme, which is the wellbeing principle in section 1, and a decent chunk of the urgent care act judicial review work I do is Article 8, sometimes Article 3, if it's a really horrendous case, Padfield breach of the discretion in section 19 and failing to comply and actually actively frustrate the wellbeing principle. NHS continuing healthcare, I would be interested to have some discussions later when we have the sort of wider discussion about local authority versus NHS going against each other, not agreeing to fund it, saying it's the other one's responsibility, classic issue that comes up in Court of Protection. Again, I've got the legal framework and duties on the slides. I'm really out of time. I don't want to eat into either Susan's time or discussion time. And much of this will be familiar to you. Endless delays in the Court of Protection proceedings when you've got a decision support tool, decision outstanding. This seems to be sort of the bane of my life in these types of cases. What people do about that in practice is something that I'd be really interested to discuss later. Appeal process against NHS, CHC, I've included this just so that you have it and you have all of the detail to hand. The national framework is obviously invaluable when sort of navigating NHS, CHC. Always have that to hand if that comes up in a Court of Protection case. Out of time, you'll have the slides on this. Children's services, I'm not going to go into the details of all of this in too much at great length. You've heard about IROs earlier today. I'm assuming most people know what a looked after child is, but and the section 20 definition, if you don't, it's all on the slides and you can look back later. Education healthcare plans, Susan will be speaking about those, so I'm not going to do that. I'll briefly mention the section 17 power. It's a general duty, and again, remember sort of the underlying purpose of that and compare that. It's about promoting the best interest of the child. Section 17, Children Act, not Care Act. Perhaps I should not use CA as abbreviation for both, but it's always think about the underlying statutory purpose when you have a discretionary duty or power. And then transitions to children's to adult services, we've touched on that already this morning, and I don't want to go early this afternoon, I don't want to go into detail on that. Disabled facilities grants, really important if you do that type of work. I think it's probably been covered in more detail in the housing session, so I'm again not going to go into that, but you'll have the slides. And thank you very much. That was a complete whistle-stop tour, but I hope you have the slides for later, and they're a valuable resource. And I'll hand over to Susan.
I wanted to ask a question before we move on to education, and that relates to your suggestion to consider a JR when you have a circumstance where directions are being made over and over again, the Care Act assessment's not being done, the carers assessment's not being done, etc. So I just recently was involved in a case that isn't for anyone in this room, so I won't go into detail. But when I first looked at it, it was an 8,000-page bundle, and I thought, oh my God, this is going to take me ages to get through. And I had about a 30-page brief, which just recapped what happened at every hearing, which was the local authority hasn't done what they were directed to do, let's come back again. And literally, of that 8,000 pages, almost nothing advanced things. I've never seen a case like that took so much time and resulted in so much paperwork, and yet nothing was happening. And I just wonder, are there alternatives before you go sort of postal and decide to JR it? What would you do before it got to the point where it's sort of 8,000 pages and 15 hearings and nothing has happened?
First of all, that sounds horrendous. I'm really sorry for you to have to read 8,000 page bundle, but also I'm really sorry for P at the centre of that. That's been so badly let down by a system, and that can be the frustration of the court of protection, is how much teeth does it really have if the local, obviously it can go into, there can be cost penalties, etc. if a local authority is really not complying, but ultimately the money questions are outside of the Court of Protection's jurisdiction. I don't consider it to be going postal to go into, to send a pre-action protocol letter, and would be inclined to do that, depending on what you think the real reason is for this. And one of the things that we hopefully are going to discuss in a bit is just siloing between departments in a local authority, and what strategies you can use to break down the silos within a local authority. Social care, not speaking to education, for example, being a really classic one. I think a PAC can be some of the best way forward on this, because it can get it into a different lawyer's remit who can then be like, look, we're going to lose a judicial review. The problem is, if you're in the court of protection and it's subject matter of the court of protection, they may go and say you've got an alternative remedy and it's being dealt with in the court of protection. So you've got this balancing act, because the court of protection has a circumscribed jurisdiction, but obviously it also has specialist expertise and can look in the granular detail of what's happening on the ground. And an admin court judge is going to say, this matter's been seized by the court of protection, I don't want to have a look at it. But there will be cases where there'll be hard-edged statutory breaches where actually the court of protection judge isn't the right forum to deal with it, and sending a PAC letter. There's obviously also ombudsman, there's a whole range of other remedies, but I think it's a PAC is my view. But maybe let's open up the floor.
Would you recommend certain directions, or depending on which judge, if you were in front of Judge Hilda, for example, or certain other judges, she'd be like, if you wrote things on the order like, we've tried everything possible sort of thing, we've done this, we find it this, we can't do anything more, that would stop your high court admin judge going to Court of Protection is seized of it. Are there directions like that you would advise to assist in JRs?
I was just going to sort of, probably on your point of it, James, I think sometimes it's literally sort of spelling out the impending breach as it's, yes, it's happening, yes. I think maybe we all have a role as lawyers to be there, confidently saying, these are the duties, it looks like you're in this framework, why aren't we there, and it empowers the court. And I think the court's becoming more familiar, certainly over the last few years, with those duties, and so I think people consistently doing that and spelling it out on the way, and hopefully they get to as far as reactive, but inevitably that may be.
You also know that the chief executive comes to the hearing and explains themselves, and I mean that's never happened because, well, we've had that direction and then they've done it. So I've never met a chief executive, so it's quite a benefit.
And it's interesting, I've had cases when it's like the chief executive gets involved, why can't we just pay it out of this budget? And they just somehow miraculously find the money which is there, but it's just in the one person's budget. But yeah, I've had lots of that, and sometimes it does work.
But I think the question is also, at what point do you say, okay, we've tried everything? At one point, obviously it comes before you've got 8,000 pages and nothing has happened. But at what point do you do that? Having in mind, I would say there's a poignancy to the failures to conduct the assessments, because getting to your point about the funding, they're not saying we're not going to fund this, that, or the other. They're saying there aren't any identified needs. Well, why? Well, because you haven't assessed them, right? So they knock on. The question is, at what point we should be intervening before it becomes a problem that's almost too big to fix.
Well, it's a reasonable question, isn't it? It's a question of reasonableness. Because how long can you wait? What is a reasonable length of time for a person to be without a care package because they haven't assessed?
That's, I think, goes to Ollie's point, going understanding the underlying legislation, because in what's your background, talk about the education, healthcare plans, they all have best practice guidelines and guidelines that this should happen within a certain period of time, and all these care needs assessments are supposed to be done in. And I think it's just, as you say, it's still a question of what's reasonable, but that's the starting point, isn't it?
And I think by the time you reach 8,000 pages for a straight public or delay for you,
mustn't it? Yeah. Well, that leads beautifully on to siloed thinking. I have to say that initially, the first few times I had real education issues come up in the protection context, it was basically the local authorities saying, nothing to do with me, I don't know anything, those people in the SEN team, they're the flakes, I'm here, I'm doing everything I need to do, we just don't get a response from them, and then you get the runaround from them. So initially, when this topic was mooted, I thought, well, that's the only thing I can talk about. Is there any other way? And I think the way forward, and we've done a lot of talking, but I'm really interested in hearing what others have experienced. For example, if you have a situation where SEN is not doing what they need to do, an idea might be, and this wasn't a case of mine, but someone else in Chambers, built into the directions a number of RTMs, with some RTMs having specific agendas to deal with the education points with inclusion of the SEN team. So not the typical invited sort of fluffy, because they can always say no, or they can say, oh, we weren't given enough notice. So if you set that out right from the beginning, that whether or not they come to court is less important than them being present at roundtable meetings at which a lot of these things are being discussed. And more importantly, a lot of these things are being actioned. I mean, that's what you have to work at, how to break the logjam, because my experience has been that within the local authority, it's very rare that you get someone who's there who says, yes, I've got really good contacts within the SEN team, we share information. That's just not the case. And often they're looking for you, that's the irony, they're looking for you as the outsider to break the logjam. And I mean, I think, of course, it's fair to say, well, you're the local authority, you should be working it out yourself, but they've tried and it hasn't happened. So that's one thing. Another thing is pretty obvious, so I apologize if it's just blindingly obvious to everyone here. Always make sure you get disclosure of the EHCP, because often that doesn't happen. So you may not even be aware of the fact that there is a plan that is lying dormant, that, for example, hasn't been reviewed on an annual basis. Or if you're representing a parent, for example, and it's very difficult to understand how to support the parent, how to help them see what the entry point is. Often, of course, they've got a role to play in plan reviews. So that's a way of engaging them and engaging the local authority and pointing out to them, if you've not reached out to the parents, that needs to be done, the review needs to be done. I have to say, I think, I don't know what others' experiences are, the annual reviews are not taking place every 12 months in my experience.
The meetings might be the decision.
That's exactly right. The meetings often are, but not the decisions. Another thing to think about, and when you were talking about CHC before, CHC appeals, whenever you have COP and parallel proceedings elsewhere, you always want to turn your mind to getting permission to share documents. So if you've got a CHC, sometimes if you're for the OS, for example, it's not you, it's someone else who's appealing a CHC decision. For example, sometimes it's a family member who actually is the applicant, and they don't know that they can seek disclosure of the COP material with respect to the CHC appeal. So I've just had one of those where the person quite understandably just didn't know that was an option and didn't have almost anything to support the CHC appeal. All of the juicy stuff was in the COP proceedings. Similar, if you have a parallel proceeding in SEN, then you can
seek permission to share information. Often, if you have expert reports, for example, that have been hard fought, maybe you have P who doesn't engage very well and is very reluctant, it's really, really important to take every advantage of those expert reports and make sure they get shared, obviously with permission from the court, but shared in other parallel proceedings. I think that's underutilized for sure. And especially if you have someone, even if in the parallel proceedings, it's possible to get a direction for another expert report. Often P doesn't really want to be at the sharp end of another expert assessment. They're over it, and especially if they've been assessed a lot, often the quality of the assessments are reflected by their discussed with the whole process and their sort of general disengagement. So I think that's really important to keep in mind. I just wanted, it was something that was touched on this morning. It really does seem like a long time. I think it's because it's so dark. Probably people at home are like, no, it's nice and sunny here. It's not dark. Relative to educational placements that are residential, really important to keep in mind that they raise their own issues of deprivation of liberty, right? And as has been referred to already today, the parents of a 16 or 17-year-old can't give permission, can't give consent to that. That's a problem that may not be obvious to a parent, and so it needs to be approached with some sensitivity. But you can find a case that begins in the COP, and the COP is effectively taking the lead. And then what happens is there's a residential educational placement, and all of a sudden that's where things are really happening. And the deprivation of liberty, for example, the issues with respect to that are playing themselves out in that educational setting. Now, there are a couple of ways of dealing with that. One is getting yourself back in COP again, but it's really important to anticipate this as a likely problem, especially when you have an educational placement that goes on for an extended period of time, and there end up being more problems as time goes on. Also,
what about the day school? Because if you just go to a day school and you go to your care placement at night, but you're inside the statute amounting to deprivation of liberty during the day at your school, does that need separate?
It wouldn't be deprivation of liberty, it's just day at school, would it?
It's every day.
Yeah, it would.
But it wouldn't be standard authorization.
No, so I was just asking, like, would you, because your EHCP could say that, couldn't it? Your EHCP could say, this is what you need, this is what you have, and it amounts to deprivation of liberty, but do you then need separate authorization from the COP?
Yes, because the Sen Tribunal's decision is not is not compulsory. It is an option that you are saying you've got an option. The local authority's got to place the school. The parent doesn't have to take it up.
Right.
I think it's not a mandated responsibility on the parent. Whilst if it's a dole's from a court protection, best interest is to live there in that place. That person is kind of very bad use of the word and what is forced to go there. Whilst with an education healthcare plan, it's an education healthcare plan that says the local authority has to pay for it if the parents send their child there, but the child is enforced by the Sen Tribunal to go to that school. That is where the slight distinction is. That's why the Sen Tribunals never have to worry about if it's a deprivation of liberty or not. They just go, that's where he needs to go, he or she needs to go. Then there's all the other stuff that falls outside it, which is the placements, etc., have responsibilities to authorise it in the correct format, etc.
So you need to apply for the COP straight after
if the necessary test is met. Yes.
But then another thing that often happens, which I think is a bit fuzzier and attracts less attention and less consideration, is when you have someone who's a bit older, and so the transition from childhood to adulthood is underway, and this sort of social care side of things seems to be taking a back seat to the educational, then you can find a situation where, I think it was intimated in your slides, you can have a situation where there isn't an assessed need, and so it's discretionary to the local authority as opposed to something that they have to do. So the point is that once you see the shift and the educational is sort of taking the lead, you have to be live to the possibility that the social care considerations are falling off, and they in circumstances where they shouldn't be falling off. And just to remind you, apologies if everyone is aware of this already, but with all the talk about the Dolls Court, of course, it's also important to remember that Section 16 cases, the court has jurisdiction from the age of 16, and of course Section 21A challenges 18, but sometimes the 16, relative to your question about dolls, I think a lot of practitioners seem to overlook the jurisdictional issues with respect to Section 16. And then, again, something that crosses over in a number of different areas, planning for the transition from children's services to adult social care. It tends to be more reactive than proactive. And what often happens is you inherit it as a result of the fact that there hasn't been the advanced planning. And for example, education issues haven't been considered. And a lot of people don't appreciate that, of course, education remains an issue past 18, well past 18, 19 to 25-year-olds, in fact, have EHCPs and have free access to further education. CARE Act assessments also need to include the assessment with respect to training, with respect to education. And so to the extent that maybe P feels the educational component falls away, of course that isn't the case, and you need to be pushing for the assessment to include all of that. And then just wanted to come back to areas where the local authority has discretion, but I wasn't sure, James, when you were talking, whether the point that you made was heard, that yes, it's true that it's not mandatory in the sense of parents not having to take it up, but it is mandatory, the point you were making, that the local authority still is required.
It's an obligation.
It's still a statutory obligation, right? So don't fall into the trap of thinking it's not mandatory from the perspective of the provision of local authority. But there are, I just wanted to give the reference to Section 19 of the CARE Act, where you don't have assessed needs, but where the local authority still has the discretion, not the obligation, but the discretion. And then a reminder that, of course, there is also power to provide, again, discretionary, to provide Section 17 support extended to the person who turns to 25, if in fact the plan is maintained by the local authority. That's something that's overlooked a lot, but I think is quite important. I'll send out all of this, and what I have then gone on to do is give some details, some key materials and resources with respect to SEN appeals. But I think it's beyond the scope of what we're going to talk about today. We did want to talk about a couple of things that Ollie raised before we run out of time. One, questions about legal aid, exceptional case funding, and then the point Ollie was making about boundaries with public law decision making, which of course also has knock-on effects to funding. Did you want to talk about your experience with exceptional case funding in SEN matters?
Yeah, sure. I mean, education legal aid is a disaster. I think everyone would probably happily, well, not happily admit that. Does anyone have an education legal aid contract in the room? No, some, yeah. So the way that legal aid works is, for SEN tribunal appeals, is you have legal aid up to the tribunal door. I know you don't do it. You have legal aid up to the tribunal door, and then under legal help scheme, then you apply for exceptional case funding. And there's been an issue around capacity recently in how exceptional case funding applications have been determined, which has hopefully now been resolved, which is in the SEN tribunal, they have an alternative to the litigation friends scheme called the alternative persons scheme, And an alternative person is a party to an appeal, not actually just a litigation friend where the child remains the sort of claimant / appellant. It's wholesale substitution by the appropriate person. And the legal aid agency's means test is done in relation to the party. So ordinarily, a litigation friend for a child means not assessed, but for a party, they are. And so you can have an alternative. The right of appeal starts at 16 in the same tribunal for a child or young person. So 16 to 25 because children and family that decisions are in relation to that cohort too. And what was happening is that a disabled child or young person who, by virtue of their type of disability, lacked capacity to litigate, was being substituted out for an alternative person. They were being disadvantaged in terms of accessing legal aid because instead of their needs being assessed, and if they qualified, they would get legal aid, they were being substituted in with a parent, grandparent, whoever it might be, who might not be financially eligible for legal aid, and they lost legal aid entitlement, which seemed quite obviously discriminatory. And the legal aid agency seems to have backed down following a pre-action protocol letter on that. But the more fundamental problem is education, legal help rates are a disaster, and they're really hard for any firm to do the work, unfortunately, and we should all be outraged.
Why would you ever substitute something there? You substitute the Helen?
If the young person lacks capacity, they're automatically substituted for the alternative person.
Instead of a litigation friend, it's a sort of parallel scheme where technically, just by operation of the same tribunal rules, rather than the Children and Families Act, just because if a person lacks capacity in that forum, there's no litigation friend scheme. So the alternative person is effectively the litigation friend, but for the purpose of the legal aid agency, they are the party. And therefore, that means if you, on a sort of computer says no sort of approach, not really thinking it through, their means get assessed, and then loads of people fail their legal aid eligibility criteria and therefore deny sort of access to legal representation. But that seems to have changed, I hope. They seem to have backed down. But the alternative person scheme is quite an interesting one. I don't know if many people have had experience of that in the Central Tribunal. Yeah. Don't know if you want to speak about it a little, and like how it's different or caused any difficulties.
I don't think it does. I mean, I don't do legal aid work though, so I can see in legal aid work but effectively, because in the Central Tribunal generally it's the parent that has a right to appeal anyway. It's just when it's a young person, the right reverts back to them, and if that young person in that capacity, the right effectively reverts back to the parent, which is generally the alternative person, which is generally the parent. So actually, it runs in a very, very similar way. Not very often local authorities will, if you assert the young person that capacity, very, very few times will local authorities ever dispute that. Now, I always do a contemporaneous attendance, I always meet the young person and all about for my purposes, so I've got that contemporaneous using attendance and if we're challenged. But I only got in one case where the local authority challenged and said, hang on, use your above those capacity. So generally, it doesn't. You just run these in the same way.
The same duties. Do the same duties apply to an AP that apply to litigation to the whole Part 21 stuff?
Like in terms of that best interests. See, the legislation doesn't actually require that, does it?
But it's in the same code of practice, but that is pretty much the same.
So you have a parent who might not be able to act in best interest of the child for whatever reason.
Yeah,
but they are automatically in terms of you can't go fishing.
Isn't that usually problematic? What do you do with a parent who
is
for whatever reason doesn't want to appeal the HCP or wants contents in there that clearly aren't good? Because you wouldn't choose that person as a litigation friend, so it seems weird.
No, but then in Central you have the same problem in terms of discharge. Parents like the bill. Parents can sometimes be asked some things that arguably may not be in the child's best interests. So I'm not saying it's right. I'm saying it's right, but that's also how it operates. Generally, you'll find that if the parent is going to all the trouble of instructing lawyers, spending all that money, getting the experts in, they've generally got the best interests at heart. Yes, sometimes they need to take them for a journey, and that's part of the role. But I haven't had any real problems. But I don't know, other people might have done.
I've seen it in a couple when there's education issues, and the mum is, or the parent is a separate party. They often have very strong views that maybe on the part of the OS we would oppose. It seems weird that they would be the AP.
Well, we had that in a case where we were actually parents in court protection, and we would be AP in a parallel assembly.
And broadly, what happened?
Oh, that's again.
Okay, fine. I've had issues where, because alternative person is a sort of prescriptive list of people that can be an alternative person, and I had one central tribunal appeal where they had a number of interlocutory hearings just about whether we could go outside of that prescriptive list to be an alternative person without going to the Court of Protection. And ultimately, the Central Tribunal exercised its discretion to treat another family member as the alternative person, even though they weren't on the list. And it saved us going to the Court of Protection and the delays that were involved with that, which is
Grammatically, that's right, but is that right as much as well?
Good question. We managed to convince the Central Tribunal that was correct, and it hasn't been appealed. So, and it all happened much faster.
Do you get a written judgment about that or not?
We got a decision that had some reasoning in it. But yes, query whether that was the right thing, and I think the local authority were considering appeal. They preserved their right of appeal pending the outcome of the final hearing, and we won a lot on the final. We got everything we wanted in the final hearing, and we were worried about them appealing specifically on that point later. Ultimately, it didn't happen.
And does the SEN guidance address what the process is for removing the alternative person?
Well, no, Weston does.
Because there's that nasty case that made its way through the High Court about someone who wanted to be released as litigation friend, and
and whether that was forced labour.
I mean, it was pretty. The facts were pretty appalling in terms of her explaining her reasons for not being able to serve as litigation friend anymore. And at the first two levels, the High Court judge said, "Don't care, not interested. You don't leave until I tell you can leave," kind of thing. I mean, in the end, that view was criticized, but the point was that it really highlighted what I would say is a real problem from a statutory perspective, because it allowed that to happen.
I suppose it could happen, right again, that you're a 20 person will be here. You don't want that, because they're the party.
Yeah.
It's pretty heavy.
But then...
And the local authority's not going to look yet. But who is going to stop them? Like, if you need permission of the tribunal, but which is going to be granted, right? Realistically, but I think I guess if there isn't a suitable alternative person, or the person who's currently alternative person feels they can't go onto it, I guess they possibly would go to the Comm at that point with someone identified. If the tribunal didn't feel it was within their powers to identify and name someone, exercising the discretion about as what happened in our case.
So unless Ollie's representing you, in which case the rules don't apply.
Well, I guess that was maybe on one. We had to. It was an arguable stretch of the principles, but I think not completely untenable and a reasonable decision for the judge to reach. But I think if it could easily have been an appeal point if it had been appealed.
Do you think if you've got ongoing properties where the education issue comes up and you're expecting the Central Tribunal case to come up, you could ask the Comm to appoint, or say it's in his best interest to have this person as the AP? That's something you could ask the Comm.
The Comm hasn't got jurisdiction of the lands out there.
But the question would be, is the COP has the ability to...
James is a Central Tribunal judge, so...
No, I'm saying the court protection does have the ability to make decisions and declarations in respect of who, for people who make decisions about the same person, whether that is a deputy, whether that is, and so forth. So I think, in reality, the court protection has the ability to apply, say, only mum can apply because dad is a dangerous person, whether that is an injunction or whether that is a deputyship order or what is the question. But the court protection has the ability to stop people making best interest decisions, which would be education, which would be applicable in the central review because we can't ignore it.
So it could, for example, if there's two parents, it could say, well, this parent should be the alternative person.
And I know from having spoken with other judicial colleagues is that when there are separated parents, there are a few, not a lot, when both parents try and bring applications and have arguments in court to get the courts to make decisions in respect of which schools the children should go to and so forth like that. That's an interesting thing that full-time judges make decisions on and deal with. And they work at ways, they work at ways around it, because the reality is the law is our applicable law is very is the best interest, not best interest decision, but in that sense is we are looking at what that child needs. If mum and dad are just arguing about the naming of a secondary school, go to the family court or go to the court protection, really, I think we would say, if we can't decide on which of these two schools. But in theory, we could name it. Still, if we wanted to, we could decide which one's more suitable than the other.
Any questions from?
Before we are about to wrap up, but just jumping on that transitions point that you were both making, I think it is really key for all of us to have that transition ahead. And again, the care assessment process, the transitions assessment that can take place, and have being bold as lawyers of flagging these things within the court protection proceedings, it end up being public law points, but yeah, I think it so often is kicked into the long grass along the way.
And often, just on that point, often local authorities have their own guidance that says, for example, everyone's got their own calculation, but when P is 17 in 2 months, there will be an adult social care worker named. So now I say, okay, I'll have that name, thank you very much. Because of course they don't have the name, but they have the policy saying that that name exists somewhere. And if you ask for it at the earliest possible date, then you find out it doesn't exist at the earliest possible date.
I've also seen moves deliberately put beyond the 18th birthday, hearings being sought, well beyond.
Yeah.
So I'm sure we've all experienced that, but it's
I think the judges are becoming more and more aware of the court judges, especially the ones who sit at First Avenue House knowing your lawyers. A lot of them now require, like Hilda will ask you, if you've got a 16-year-old who's about to then go to 18, I want that name now in the next 6 weeks. I want to know who the professional 1.1.2 representative is going to be. I'm not concluding this case. So I think she's stretching her powers because I think she wants.
I guess you could compel them to attempt.
Yeah.
This person that doesn't exist, but is there.
Yeah. Joe.
I just want to ask, because I'm a community care, are there any risks to going to the court of protection? Because I'm thinking of clients that essentially, like, I would be a bit wary of things spiraling out where actually, do you have capacity to do this? Do you have capacity to do that? And all of a sudden, and I'm worried that if, for example, thinking about his education and the fact that, or someone's education, the fact that that's getting ignored, potentially court protection could be a helpful way of finding best interest. But I wonder, are there risks that it then spirals out and starts eating up his every other aspect of the client's life, or can you keep it on track?
I would say almost, I'm happy to be corrected. I would only say the opposite, of course, because there's a presumption that everyone's got capacity in all the different arenas. So that's the starting point. So I wouldn't be as concerned. But you're right. Once you open that can of worms, you're going to have to, and in order to engage the COP, you're going to have to assert that there are questions about.
But I would say the COP is quite good at not going down a rabbit hole, because you have to for a specific application. Yes, you may have questions about loads of different areas of capacity, but it's decision specific on a specific issue at a point in time. Is that the COP doesn't go, let's assess the capacity on everything and anything. That would be, do you disagree on me?
Thinking about what your caseload probably is, Joe, like, are you thinking of potentially bringing judicial review claims and instead going to the Court of Protection, and how that might cause issues? Because I think, as we discussed earlier, like the Court of Protection is obviously got a great deal of expertise that will look at the facts in a way that a High Court won't. If you go to the Court of Protection, you may be creating some barriers to judicially reviewing because it's an alternative remedy. And obviously it has jurisdictional limits, but you'll have to think very carefully about how you explain the limits of the Court of Protection's jurisdiction and how that applies to your case if you ever wanted to bring a judicial review claim. And as discussed earlier, strategy, careful thinking would go into what you put in the orders, the recitals, to make it clear as to the scope of the Court of Protection proceedings and exactly what is going to do and on what timescale, so that you're not actually just keep putting your client into the limbo of the Court of Protection and denying them a perhaps faster, more effective remedy, because actually the Court of Protection can take years to deal with an issue, and it may actually be that the local authority doesn't mind being on the conveyor belt of the Court of Protection, which is generally a no-cost jurisdiction in the health and welfare section. Compliance with orders is variable. Some people are more some judges are more assertive than others, so try their luck on the judge you're going to be in front of. That could lead your client into a limbo when actually a sort of urgent application for judicial review interim support please might be the better way in, and Court of Protection can be a fig leaf unless it's being used in a sort of very focused and specific way, in a way that the admin court won't look at something.
I'm just thinking for 16 to 25-year-olds, we found the SEND tribunal for social care has been quite a useful tool. Because yes, I appreciate it's only recommendations, but generally local authorities will follow those recommendations, and the tribunal will look at it, and you can get your independent social work evidence and so forth, and I think really will help you can probably get that evidence funded and so forth. So just bear in mind that is a potential opportunity for constantly find themselves in legal help.
But thank you very much, everybody, for your participation.
We're going to talk a little bit about what the framework is for that. And so, as Court of Protection practitioners, what do you need to know about your clients of insecure immigration status who pop up? What can you do for them? And then we're going to talk a little bit about we're going to do some case studies where we look at some particular examples and how your Court of Protection practice might inform what you can do, what you can achieve for individuals who do that capacity. Take it away, Emma. Thank you.
So we're looking at how capacity arises in detention, and then what's the impact of that on your substantive immigration claim. We'll look at when and how it should be assessed, and then more practical issues around the COP and practical capacity. Just a brief outline. Some of you may be very familiar with this, so this is just kind of a quick summary of the immigration detention powers. So Secretary of State obviously has statutory power to detain, and it's set out in a number of statutes. You'll find them in section 61 of the UK Borders Act. Essentially, the power arises either when she wants to examine a person's immigration status, if she wants to facilitate removal, or if she wants to facilitate deportation. And for those who are non-immigration specialists, there's a slight technical difference between removal and deportation, because deportation is a specific term of art in cases where there's a deportation order, usually in cases where you have criminal offending or other reasons to justify deportation. But both terms are used sometimes interchangeably in the press, and they refer to removing a person from the UK. In addition, it's also worth being aware that there's no express time limit in statute or any rules as to how long a person can be subject to immigration detention for, which you might consider surprising. But there's been growing momentum, particularly in the last couple of years, to impose a statutory time limit. And the Brookhouse Inquiry Report, which was just published in September, has recommended a 28-day time limit for immigration detention, which is very common.
Can I just butt in at that stage?
Sure.
So, one of the reasons why Strasbourg says having a statutory framework permitting indefinite detention is lawful is because of the prompt and speedy access to an Article 5 form review and legality of detention. But obviously, if you lack capacity to bring that, you lack litigation capacity, you're not going to be able to do that. So
the questions of capacity arising in the detained immigration estate context raised quite big issues about Article 5.
No, that's really, really useful. And it's also just being aware, I think this is a crossover for mine specifically to your case studies. Sometimes the cases with capacity issues are among the more difficult cases in terms of deportation because of potential criminality or issues of perceived compliance. And so to be aware that there's a very strong public protection element in immigration detention, and when you're looking at immigration detention documents or bail summaries, there can be mischaracterizations or factual inaccuracies about offending or compliance, and in public law terms that should all be very robustly set out by the Secretary of State. It needs to be accurate. In terms of the limitations on the powers, one's already referenced Article 5 is a very strong limitation. There's also Article 3, particularly in cases where you have very vulnerable people in prolonged immigration detention who may need access to specific kinds of support and care. There's also the guarantee against degrading and inhuman treatment. And on that point, it's also just being worth aware that the Burke-House inquiry identified 19 breaches of Article 3 in a 5-month period in detention. So it's already the case that people who are in the immigration detention estate are at risk of suffering a serious breach of Article 3. And that's going to be particularly so where they're a highly vulnerable population. You also have the adults at risk framework, which was introduced as a, in theory, mechanism for protecting very vulnerable people in immigration detention. But in practice, there are concerns that it's actually led to the lengthening of detention for some vulnerable detainees. We'll give you obviously the links after the seminar to the various policy documents on that, but essentially adults at risk is formulated on a 3-level approach, so levels 1 to 3, and the higher the level of evidence, the greater the level of protection, and the narrower the justifications become for detention. There's often fights about whether or not evidence reaches certain thresholds and whether or not the exceptions apply. The adults at risk policy is supposed to be, in theory, supported by the detention centre rules, which should be, in theory, again, identifying people very promptly who are coming into the detention estate. And in particular, Rule 34 says they should be having an examination within 24 hours by a doctor. That often doesn't happen in practice, either because it's a nurse and therefore it's not Rule 34 compliant, or detainees don't necessarily understand that the purpose of the assessment is to potentially screen out them from detention, and so don't often consent, but it's not valid or informed consent in circumstances.
Obviously, if you're away with the ferries and you think that the Home Office is in with a doctor and they're trying to frame you for something which is not unusual, you're not going to be flagging up to your doctor in detention or your nurse what your mental health or other concerns might be. So for lots of reasons, I think one of the things that came out of the Burke-House inquiry is that both the Section 34 and the Section 35 protections in the rules, the Rule 34 and the Rule 35 protections are very detainee-led. So, if the detainee isn't initiating that transfer of information, that complaint, that concern, if they don't do it, then you're fine. And indeed, I've just got a difference back in a detention capacity case where throughout the statement of the Home Office witness, it says no concerns were raised. No concerns were raised. Well, your very ill person isn't going to raise concerns.
And to that, if it worked properly, you would have someone come in promptly within 24 hours, be assessed by a doctor under Rule 34. If there were indicators of vulnerability, that should lead to what's called a Rule 35 report, and that identifies either that detention is injurious to their health, that there's suicidal ideation, or that they are a victim of torture, and that should obviously prompt a review of detention. But in practice, that often doesn't happen until much later in the process, and even though Amanda says it's very much when someone discloses it, possibly after an asylum interview, possibly after they've been served with removal direction. So the system doesn't work in the way that it's supposed to.
Yeah, it doesn't work, and doctors often don't understand what the purpose of Rule 35 is. They don't understand that if they don't make the Rule 35 report, then
then nothing's going to happen about releasing somebody, whether they're vulnerable or not. And then, of course, some, like in the Brookhouse inquiry, the GP is disingenuous about the whole process and doesn't actually stand in the way of anybody's detention or deportation, regardless of how they're presenting. That doctor's name is Dr. Uzurali, and the chair of the inquiry has made a report to the board.
It may be a sharp contrast to other practice areas where you're used to dealing with assessments, that the quality of the assessments and the recognition of vulnerability in immigration detention is very poor in comparison to other areas. I think you may encounter.
It's a bit like also the forensic psychiatric estate, where difficult behaviours are very much seen pejoratively rather than as a symptom of the illness that the person has.
So just briefly move on then to Hardy Singh. So Hardy Singh are common law principles that they limit the Secretary of State's exercise of her powers. So essentially the common law says that she has to exercise her powers for their intended purpose, that they should only be detaining people for a period that is reasonable to facilitate either removal or deportation. Once that period has expired, that they're no longer going to be detained. And throughout the process, the Secretary of State should be diligent. Just to put on the slide there, that unfortunately has been the subject of a very recent enactment in the Illegal Migration Act, where the Secretary of State is trying to put this on a subjective statutory basis. So traditionally, the court assesses whether or not something is Hardy and Singh compliant, but the Secretary of State has tried through this new provision to say it's the Secretary of State's reasonable assessment which the court should be guided by. And that's yet to be litigated, as it's only very recently come into force. But the other colleagues here have strongly advocated that Article 5 requires that be read in the objective sense that was already stated.
It has to be an independent and impartial review of the facts and
then finally, just for completeness, there are general policy instructions on immigration detention, and aspects of that can be helpful in terms of reasons why release should be considered. For example, if people have pending immigration claims with the Secretary of State, that's seen as a indicator of compliance in terms of their ability to report on bail, and is often overlooked. So that's a very short overview of the power and the limitations. I think we perhaps move on to the client cohort.
Am I doing that? Right. Okay. So yes, who might fetch up as a part of insecure immigration status? So here we're not just talking about individuals who are looking to be released from immigration detention, or individuals in respect of whom somebody's flagged up a concern that they shouldn't be in immigration detention. There will also be people who fetch up on a street homeless with all sorts of difficulties, and then it's only when you try and sort of work out what their entitlement to benefits is that you realise that they're not entitled to them because they're in insecure immigration status. And I don't know if you're familiar with that Hayden J judgment about the Zimbabwean gentleman who needed to have his leg amputated, and he'd been sort of subject to the hostile environment for months and months and months. And Hayden J expressed that in this day and age, it was somewhat concerning that he'd sort of been rattling around in the streets for a while with insecure immigration status, just getting iller and iller. Anyway, so these are all the sorts of situations that the individuals cropping up might be in, and I don't think I can underplay the impact that months and months and years of exposure to the hostile environment has on a person. I remember an old Mind poster about homelessness, about street homelessness, where it said something along the lines of I'm ill because, and then a sort of list of all the conditions that they've been exposed to while living
street homeless, and that had resulted in accumulation of matters which triggered mental illness. And in a very real sense, migrants that you come across and people of insecure status are going to have a constellation of problems which have been exacerbated by the hostile environment, and picking those apart and working it out is going to be difficult, because there'll quite often not be a GP record that you can go to. It'll be a question of trying to get people assessed by minutes. And we've added in there early identification key to ensuring access to justice and fairness. The quicker you ascertain that your client may not be able to give you instructions, or might need support to give you instructions, or may have a deteriorating medical illness, which if it was dealt with might improve their capacity. So, for instance, I had an Italian citizen, this is pre-EUSS, pre-Brexit, but he was sort of knocking around, and he had HIV, and he had HIV-related dementia. When he went back on his ARVs, after about 6 months, he recovered his capacity. So, those are the sorts of situations that you're going to come across. What's next?
So we just drew together what a capacity is particularly relevant for immigration detention. We've already touched on that, but I think the important point is that you become liable to immigration detention if you are liable to be removed from the UK. So that's the relationship between the two. And obviously, if a person lacks capacity and needs assistance to express why they should stay and how to make that claim to the Secretary of State, they're not going to be able to put forward why they shouldn't be liable to detention. And therefore, they're not going to be able to explain once they're in detention why their detention is unlawful or why they should be bailed. They're not going to be able to advocate for why they should be in a different kind of setting if detention is contrary to their needs. And also, I think in terms of the real life impact, it puts people who are really vulnerable at quite a cruel chance of being exposed to very short, no notice removals, or being subject to the inadmissibility process. The claims not considered, or the claims dismissed very quickly, in circumstances where they may not even understand the procedure in the first place, and that can cause real alarm and distress. And they're also already in a very contrary to their needs environment in terms of prolonged detention. They won't get access to quality mental health care, for example. So it perpetuates this cycle of poor mental health outcomes and participation for this particular crime cohort, which is why it's really important for people who are in detention to be brought to the attention of representatives so that they can be claimed.
Agreed. So how that would happen in the context of foreign national offenders is that you have somebody having their sentence, and then when it came to the sort of a couple of months or so before the end of the sentence, probably at the conditional release date, then there would be a service of documents on that person. There is no means by which the Secretary of State checks that they understand the documents that they're being sent, and in prisons there's very little access to any advice. So you'd be automatically re-detained under the Immigration Acts. At that stage, if there is any record of mental illness or lack of issues relating to lack of capacity prior to the conditional release date, that information isn't passed on to the Secretary of State at the Home Department, and they don't undertake any inquiry. So what then happens is they'll be set for removal because they haven't responded to the documents. Under the current appeal regime, if you don't make an application to remain in the UK on the basis of human rights and get refused, then you don't have a right to appeal against deportation at all. So you procedurally, you lose a lot by not being able to respond to the documents as they come through. And that's how you end up in immigration detention, facing removal. Normally, people in detention realise they can't remove you because you're obviously ill, but they don't actually do anything about accessing representation to try and clear that out. You just end up staying all the time in immigration detention.
So the next slides, BC, which is one of Amanda's very important cases.
Well, I mean, one of the things about BC which is useful to know is that the court was clear that if you're in immigration detention and you lack capacity to engage with the immigration process, to challenge your detention, and to make any human rights applications that you need to make, then the Secretary of State has to put in place a procedure which supports you to be able to do that. Whether that's viewed through the prism of reasonable adjustments, through the prism of the PSED, or through the prism of common law fairness, all those, or Article 5 fairness, everything sort of converges on the same point, which is that whatever adjustments to the process enable you to be able to challenge your detention and to ensure that you're not disadvantaged in accessing justice, ought to be taken. And so, as a consequence of VC, the Secretary of State came up with a detention service order, which was supposed to be formulated in order to ensure that staff in immigration removal centres understood what their obligations were to protect detainees who may lack capacity. Yeah. So that was a sort of bit of guidance. Experience shows that it's made no difference at all to what actually happens, because the individuals concerned, there is an institutional reluctance to get between the Secretary of State and removal. Experts employed as part of the health services in immigration removal centres and G4S or whoever, or SERCO, whoever else is involved, there's no adequate training of individuals to recognise when a person might need support to access justice, and it will not be unusual for you to be approached with a sort of a court protection stroke community care hat on to try and find a way of getting representation for a person who lacks capacity to litigate, won't instruct anyone, possibly because they think that there's some kind of big conspiracy afoot, doesn't trust legal representation. And then you can't get hold of the medical records to get the OS involved because you haven't got authority to get the medical records. In most of the cases where I've got the medical records and been able to kick off a case, it's the whistleblower that's sent them out. So now the official system is pretty much alive to the problem, and it might be possible, and it has been possible, to get a remote assessment for a person who refuses to see a psychiatrist for the purpose of getting into court to get an interim declaration of lack of capacity in order to have a basis for the OS to get involved, and then to proceed with whatever legal process you will run, whether it's the court protection or the judicial review route, depending on what we're trying to achieve.
For your references as well, there was a second case in London where the same problem essentially.
Oh yeah, always the same problem.
And that hasn't been I think it's quite shocking to see two court of appeal cases where you have very robust judgments and declarations, and then the second time around.
Yeah, and there's still no mechanism, and in the Brookhouse inquiry, the Home Office witness admitted that the DSO on capacity failed because the consequence of having the DSO didn't mean that anybody got access to mental health advocacy, because there was no advocacy system, and there was no system of referral. So, for instance, we had militated, we had suggested things like an obligation on the case owner, if the person makes the decisions about detention at the Home Office, not the health organisation, what was providing healthcare. There was an obligation on the case owner to refer to the official solicitor, or to refer to a panel of solicitors who were used to dealing with protection of community care. But they didn't agree with that. So, I mean, this is a bit like the adults at risk policy. It's got all the appearance of being a measure that should help people without actually being one. So it's sort of more in the what it appears to be rather than the protection that it actually provides. So finding ways to get your client access to a litigation friend and then to whether it's a care act assessment or whatever they need, that's always going to be your initial movement.
On the next slide, we've also just given the reference to one of the detention services orders, specifically on adults at risk. So these are published documents that the Home Office staff are supposed to comply with. And you'll see there that it unhelpfully says that the adults at risk policy doesn't apply to those held in prisons. So some immigration detainees may well still be in a prison, even though they're technically being detained under immigration powers, and therefore you have to look at the prison regime, which is a different regime entirely, and depending on where you are in practice, maybe less protected as well. So
I mean, the general principle is, as a detainee, you're entitled to the same level of healthcare, including mental health care, as anyone who's outside the regime. I mean, that's sort of the underlying principle, and making that happen is quite hard work, but it can be achieved.
And just finally, in this section, we just referred to the case of AFK and MDA, which was the second Court of Appeal case about the declarations about discrimination. This is the case Amanda introduced at the beginning of the session that is currently on at Strasbourg. So we're waiting for decisions from the court. And it's going to look at, hopefully, Article 5 rather than Article 14, specifically in the context of very seriously ill people in immigration detention. And there are interventions from the Justice as well as bids on issues around mental health, transfers to hospital, and also grace periods and very long periods of detention.
So it's not unusual to have somebody go into the immigration detention estate, whether that's in a prison or in an immigration removal centre, with a predisposition or possibly past history of mental ill health, which isn't inquired about by the Secretary of State, and then gradually you deteriorate because you're in a non-therapeutic environment which is very stressful with lots of spice around, and and it's all indefinite, you never know when you're getting out, plus you've got the deportation documents that you don't understand. When it's just, you deteriorate and deteriorate and deteriorate, and eventually there'll be either an assessment by an in-reach psychiatrist or by some other means that you've managed to, for instance, contacting medical justice to get one of the psychiatrists to go in and do an assessment. Then you'll be saying to the Secretary of State, this person needs to be in a PICU, and then it will be a question of how long it takes for the wine for a Section 48 to in fact, now the Bracton Centre is specially dedicated to foreign nationals. It's a whole mental health hospital dedicated to foreign nationals, and being subject to hospital to the hostile environment makes you ill.
How does this case address that sort of? Is there anything within this litigation that identifies or tries to put out the need for assessment processes earlier than?
That was what we did. That was our bit. So what so there's the ASK challenge, and it's all about how it's all not Article 5 compliant, particularly the question of delays for Section 48, 49 transfer. I mean, the Court of Appeal were very obsessed with you can't jump the queue. There's lots of people waiting for a place, but that's that might work in the Court of Appeal. It doesn't work in Strasbourg because the answer is make more places. But our bit was very much focused on the UNCRDP, and the reason why we sort of focused on that is because there's lots of really interesting and helpful stuff in there about what participation in the immigration process means, what agency means, and it's about the quality of access rather than sort of discrimination. It's about equal access to the means of reviewing the legality of your detention. And obviously, if there's no system for identifying, we said this in terms, I think we set out, I can't remember, 4 or 5 criteria for a lawful process. And the first was to have a system for identifying, for inquiring and identifying somebody whose capacity was at risk.
I mean, it's so fundamental. I mean, it just takes me back to the early prison law cases I did, where you get to a parole board on a lifer case and then realise that the client you're meeting in a cell doesn't have capacity, and then being asked to go through a parole board process. I mean, it's the same.
Agreed. Absolutely. And of course, since that case of EG, the parole board rules have been changed. But it is key. It's key to have that. And pressing for a transfer is often going to be contingent on a gatekeeping decision by a clinician. I think what happened the last time I was working on this very point they got transferred out of Brookhouse IRC into Wandsworth because the mental health was better, but there was no place in Pickering, and then they stayed in Wandsworth for a while. And I found that the prison psychiatrists were much, much better than the IRC. In fact, in the IRC, this is Brookhouse, their response to mental health affected behaviours and challenging behaviours is to put you in the seg, and that's you. That's you sorted. And then make a note about how difficult you are. And then when you take the government to court, there's just like reams and reams of stream of consciousness notes by guards about how difficult you are. But there's no like, oh, maybe this person's got mental health. But yeah, I mean, going through those notes is a bit of an eye-opener because inhumanity just like jumps out in you.
I had a client who, she was a victim of trafficking, who becomes psychotic and having very clear hallucinations, and they were saying she was disturbing the other detainees by being loud and it's clearly not, it wasn't rational speech, you'll go here, but it's just, it's frightening the kind of approach generally. See, you come to look at the records.
So if we just maybe move on to look at the relationship then between mental capacity and the substantive immigration claims. The slides are quite detailed, and I'm conscious we might want to get onto the case studies, but just to kind of maybe flag in outline. As we've already said, capacity may well arise procedurally in terms of whether or not the client can give instructions about why they should stay in the UK or why they shouldn't be returned to where they're from. That arises both with detained and non-detained cases. As Amanda's already said, because of the nature of the immigration regime, you need to be able to articulate a human rights claim that ends up being refused, which triggers the right of appeal. So without that procedural step, a person remains liable to removal. There's also, as Amanda's already outlined, problems with service and understanding the documents. So there may be cases where actually a client comes to you who had got a right of appeal but didn't exercise it or didn't understand what they ought to have done, or sometimes they agree to voluntary return as well because they don't understand that actually they've got a good case for staying in the UK. Objectively, could be with their capacity as well. In terms of the tribunal as well, it also arises obviously in terms of whether or not a person is able to instruct their solicitor or give evidence to the tribunal, and we'll give you the links as well on the slides to the relevant practice notes in the tribunal.
How much longer have we got, Amy? Okay, let's whiz through the last bits. Can you flip ahead? Okay, so has there been, just go back, has there been a lawful disposal of appeal rights? Probably not, and you can start all over again if the procedure's been unfair, if there hasn't been lawful service on somebody who's got capacity, if there's been a failure to secure representation. Just because somebody's facing removal doesn't mean that you can't put it back and start all over again if you can demonstrate unfairness. And I know that will normally be an immigration solicitor that will do that, but it's important for community care and court protection solicitors to know that it's not over till it's over. You know, that just because someone's described as all rights exhausted that doesn't mean that's necessarily the case, and it very, very seldom is. Right, let's keep going. I wanted to go on to, so how to get a capacity assessment made. If your individual is in detention, use the visitors that are going in, and liaising with them sometimes. So, for instance, somebody in detention might contact a solicitor, an immigration solicitor, who then contacts you to say there's somebody in detention who lacks capacity, and you need to be making an application for a Care Act assessment, or alerting the local authority with a safeguarding referral. I mean, there's all sorts of ways that you're familiar with that immigration solicitors don't understand is a means of bringing this, bringing that person's presence in detention. You're making that apparent. And then, what if you need access to the detainee in order to make an application? There's quite serious findings in the housing inquiry which are helpful, because if you get stonewalled, you can explain what lies ahead of them if they don't give you access. Reaching out to the person who's managing detention, getting the medical reports, and what happens if the individual won't see a psychiatrist for an assessment of capacity, then you can often instruct the psychiatrist to make an initial assessment on the basis of your witness statement about what's happened when you've been trying to liaise with them, and any other information you can put together. So, for instance, I had a case in front of Holmes where we got a declaration of lack of capacity in order to begin a judicial review, where all I didn't have any medical reports, all I had was 2 witness statements and some emails from the health provider, and then that was enough to get a remote link with Holmes in the court, and Holmes spoke to him himself, asked him a few questions, and had no trouble making that declaration on an interim basis. And that means we get the OS in, and started an application for a care. We managed to get the Care Act assessment happening, and in the end he was sexually 48 to practice sector. But that's one way of making it happen, and it can sometimes be very frustrating because people won't act. But the whole point is that it's completely unlawful not having a means to address the situation of somebody who's just looking around indefinitely in detention, and that's capacity. Local safeguarding boards. I always think it's worthwhile referring your clients' cases to local safeguarding boards, because it's. I've even gone to one of their meetings about one crime, because I was sort of, this is happening on your patch. What are you going to do about it? And so, for instance, I had one client who had Finn Larkin, the psychiatrist, diagnosed my client as having brain scarring because he'd spent 18 months with schizophrenia in detention unmedicated. That's the sort of, that any safeguarding board should be anxious about that happening. And you never know when you're going to need that information. And some local safeguarding boards are quite proactive. Where are we at? We at the case studies.
These are some practical considerations if you're litigating the appeals in the tribunal.
We're going to do that. And litigation friends, some resources. Can we flip on to the case studies?
Okay.
Yay! Can we begin it up? Is that readable for people? So we've got ZZ who's detained at HMP Bleak as a foreign national offender, initially pursued to a sentence of 5 years for the index offence of arson. That immediately flags up public protection, and thereafter under the Immigration Acts. He's arrived in the UK in 2003 from Iraq. What does that tell you? Probably not removable. Applied for asylum but was refused. And granted discretionary leave to remain for a period of 3 years. What normally happens if people get discretionary leave to remain is that they would then be required to reapply before the end of the 3 years, and they would normally get another 3 years. That's what should happen for an individual who's legal protection. But his leave expired in 2008. If he lacking capacity at the time, then or even if he's sort of compromised or impaired capacity, unlikely to be on the board without making sure that he's made another application. And so he's got a strong, I was supposed to say, a string of probably called an offences. And he sacked his solicitor and represented himself. The judge recorded in his sentencing remarks that his questioning and evidence was bizarre and frequently on the tangent. That is from an actual case. So the guy goes to prison, and then within 2 months of being in HMP Park, he's transferred to a hospital under a hospital order. And then transferred back to prison again. So this person actually got a brain injury, and he's got Florida well. So just can we scroll down? The Home Office asserted in response to the immigration solicitor that the solicitors are a third party and not instructed by ZZ, so they've got no authority to act. We frequently come across that. And there is a presumption of capacity, and the detained legal team says there's no problem with this capacity. They frequently say that. Detention is maintained. Now, ZZ has got a sister in the UK who's been contacted by the immigration solicitor, wants to help. What can you do to help to get ZZ out of detention safely, and where do you start? Well, you've got to cut through the Gordian knot of getting instructions, getting a retainer. And so it's going to be a question of finding out whether the solicitor would be, whether the solicitor is appropriate to be an education friend, and going through all the normal checks that we go through and be the suitability of an education friend. If she can instruct you, then you'll be seeing about making a legal aid application for the purposes of trying to make sure that if he's granted bail and released, that he's going to get appropriate accommodation, otherwise he's just going to go back into detention. Go back into disingenuous. What you obviously want to apply to the local authority for Care Act assessment. What if there's a dispute between or if the sister isn't a suitable litigation friend, or is saying that he should just go back to Iraq, or that's just for whatever reason, having a sister, you're not concerned that you're not satisfied that she's acting in his best interest, say, and you've got a dispute about where he should live and what should happen to him. Sister says he should go back to Iraq, and you're concerned that actually that's not in his best interest. You might want to get the OS on board, and you might be even in the situation where you're making an application to the Court Protection for determination whether he should make an application to remain in the UK, or whether the sister should, whether the prospect of returning to Iraq is actually in his best interest. I mean, those are the sort of issues that might go up. I have to say, the Court of Protection I have found quite not keen in the cases where we've applied for somebody to be made a welfare deputy in the district. They're not keen with it. Has been done though, has been done, and certainly I had there was we got an order out of the court for the solicitor to act without a litigation friend to preserve the position. So when somebody's facing removal and something has to be done quickly, but there's to preserve the position, and there's a question about on what basis can the immigration solicitor act. In those circumstances, an application's been made on an urgent basis for the court to authorise the solicitor holding the ring, and that can sometimes be a better option than fetching around for a litigation friend in the time that you've got. Although we've got the information on a handout about Migrants Organised who do offer. But the thing about a litigation friend is that you have to have some litigation on foot. And sometimes it's difficult to satisfy an immigration solicitor that they can act, not in the context of an appeal, but in the context of an application.
Yes, yeah, and that's a problem which we're writing the slides because immigration doesn't have a procedural rules guide. There's no codification of litigation in terms of capacity, so there's nothing in the application stage for solicitors to look to be able to take steps to begin an application. Although it's inherent within the tribunal's own powers when it comes to appeals for them to appoint litigation.
And of course, what the Court of Protection doesn't often understand, although I think it's getting its head around better, is that by preserving a person's immigration status, you're not making them stay in the UK. It's not the end of the question for them. It's simply preserving their position in their best interest. If they then make a capacity decision to leave the UK, that's a matter for them. Or if it's decided that it's in their best interest, but regularising their immigration status will almost, I can't imagine a situation where that wouldn't be a benefit. Right, is that the end of that problem? And are we on to the next problem now?
This is the EU.
Yeah.
Go 5 minutes.
Right, I don't know if you just want to read through that first paragraph. Again, this is from an actual case. If you want to go through this one, Emma, what would you?
I was thinking, I think this is quite a tricky one actually. So obviously there's concerns there given the behaviour and in terms of whether or not it capacity. I obviously the relative being in the UK who thinks that he should go back to Romania before the application is returned seems like a red flag, and potentially a conflict there in terms of what his best interests actually are. There's also the fact he's been straight homeless, I believe, before and was picked up as a rough sleeper, which there's been case law in the immigration context about the Secretary of State's misuse of her powers in that context as well. There's been a crackdown, particularly on EU nationals who have been homeless. So that would suggest that there's potentially issues there around whether or not he qualifies under the EU settlement scheme. The Secretary of State may have taken the wrong view on that. And so I had thought that we probably need to look for a litigation friend or appoint a deputy given the potential conflict with the relative. And it also appeared that I thought that there may be an actual risk from the relatives given what's said in the last paragraph there.
This does look like a classic case where you might want to make an application to the board.
And I think if you could get a litigation friend appointed, it would probably be beneficial if it was someone who had experience, particularly with this kind of case, just given the issues at play and the fact that the client seemed hostile to what may in fact be in their best interest. And so it seemed that it may need to have someone who's experienced dealing with those kinds of cases. And I say that because I've had a case where somebody's family member has been initially a litigation friend, but the litigation proved too complex because it was involving very serious questions about immigration, detention, damages, release, etc. And it just wasn't a fair step to have them make all those decisions until the arrest was in.
I mean, sometimes, let's say that he's about to be removed to Romania, say, and in those situations you might have very little information about what the position is, but certainly you could have a circuit breaker. You write to the Secretary of State and say, hold off removing this person because it appears to us that he lacks capacity and that he may be acting unlawfully, and then we need an opportunity to make sure that he's been able to access justice and he's not being treated unlawfully, and that if and to the extent that he lacks capacity, that decisions are being made in his best interest. And then if they refuse to defer removal directions, you can have a very good day. But I mean, just sometimes it's necessary just to have that, to stop the removal train in its tracks, even if you're only doing it on an urgent temporary basis, giving them enough information about the individual's potential consequences of lacking capacity ought to be able to stop that. I don't think that there's ever an easy answer to any of these issues, but I think that more use could be and should be made of the court of protection. It's just, I think it's the link between the immigration solicitors and the community care board of protection solicitors. Because those kinds of referrals between the two, and those relationships often are the way that the solutions are found for difficult cross-cutting cases.
I think it's starting to happen.
Yeah.
I think it's just starting to happen.
Yeah.
Because I think there's tricks that court solicitors know. Because I mean, you know the whole thing about Rule 1.2, which I kind of never really understood. And so that's a rule basically of protection that a litigation friend, that the person, the centre of the case, without capacity, doesn't actually become part until the litigation friend is appointed. So you can kind of apply to the court of protection with any old person as a kind of you just need somebody really to sign the legal aid agreement, and just giving you very vague instructions to get the
jurisdiction,
to get it in there, and then as soon as it's in, then the court of protection can appoint the official solicitor. So it doesn't really matter when you describe it outside the family member who's not really, there's something. You just need something to do it, and I've done applications like that, and then since it's in court, the litigation is informed, raising the person.
And the court's very proactive comparatively. I mean, they take their responsibility to vulnerable individuals very seriously, and that's what you want. You want to have a migrant who's faced injustice to be in a court where actually the fact that you're a migrant makes no odds at all you're going to get the treatment that any vulnerable court.
I think the practice in immigration has improved in the last couple of years, that immigration judges and bail applications in particular are more alive to capacity, and they're more aware of the potential for unlawful detention in those cases. And I've had quite good experiences with different teachers and people where they're concerned, we're at the beginning of it, where there's concerns about capacity, we need to act quite properly, and they're willing to exercise granted conditional bail protectively, and that sets us up for.
And don't underestimate the safeguarding route towards a care act.
Thank you, blinking. Roger Pezzani, I'm delighted is able to be here today to share the depth and breadth of his expertise in mental health sphere. My name's Helen Curtis. I'll be talking a bit about the Court of Protection. Roger's very kindly produced more information for you to be able to take away, so you don't need to scribble notes. Those notes are being circulated as we speak. So essentially, just to kick off, what we're looking at are the two competing statutes, which you'll all be familiar with, the Mental Health Act, which, as I say, Roger's going to focus on, and the Mental Capacity Act. two different frameworks which impact on a person's liberty. As you know, Mental Health Act, including forensic patients who seek discharge from detention in hospital or liability to detention. Mental Capacity Act, where people who lack capacity, decisions are made for them on where they're going to live and receive care. And those keys, protected parties, may also have been previously detained or subject to detention under the Mental Health Act and go between the two. So there's definitely an intersection. That's what we're going to focus on today. And we'll touch briefly on the discharge pathway, possibly appropriate treatment, and also contained within that some risk management. So with that very, very brief, here we go. I'm going to hand over to you, Roger, who'll be talking about the Mental Health Act and also obviously some of the cases in which Roger's appeared. Over to you.
Thanks very much, Helen. Good afternoon, everyone. I won't take too much of your time, I hope. That's kind of part of the purpose of this. You don't have to write anything down because it's all in here with the references, quotes and stuff. What I wanted to do, I've been trying to think all day of a good analogy for the relationship between the Mental Health Act and the Mental Capacity Act. And the best I've come up with is two sisters who aren't speaking to each other, but are both responsible for taking care of their elderly parent. And it seems to me that the not speaking to each other part is the really important part. I was also on the train up reading what Richard Jones said in the 25th edition, which is now one edition out of date, about the interface between the two acts. In his introduction, he says the interface between the two acts has been described as being, quote, a difficult area of law, called PH from 2002, which is putting it mildly, in my view. And then Jones goes on, I suggested a reason for this in the preface to the 24th edition, quote, the government made a fundamental error when it decided to respond to the judgment of the ECHR in HL and the Baldwin case by legislating in the Mental Health Act 2007 for the detention of mentally incapacitated patients within the Mental Capacity Act 2005, rather than making suitable amendments to the Mental Health Act. So Jones says you should have just put it all into a new or an amended Mental Health Act. I'm not sure about that. I mean, we know that amending the Mental Health Act very often, well, it does two things. One, it creates loads of problems. And two, once the problems have been ironed out, everyone realizes that really nothing much has changed anyway. So a different way of looking at it, a different way of doing it might have been in 2005 or 2007 to have a thoroughgoing revision of look at all of the legislation and have a new act that covers both. But we didn't get that. We didn't get anything close to that. And we've got the two sisters that aren't speaking to each other. Jones finishes, debate about how to resolve interface issues between the two acts will continue. And that's, again, putting it mildly, and will not be resolved for as long as there are two legal routes which provide for the civil detention of mentally disordered people. So he's saying there will be, this is actually a really strong thing to say. There will be debates, but they won't ever be resolved. Because they can't be resolved, because there's basically a clash here, bless you. So, like in that context, that's what I wanted to speak about today, and you'll see from this that there are basically 5 broad topics. I'll try and rush through them because I'm terrible with time. First of all, the crossover between the two acts seems to me to be potentially more significant than we think. So you've got the MCA representing a potential alternative to the MHA, and vice versa. Obviously, the MCA is only available to a sector of MHA patients because not all MHA patients would meet the criteria in Section 2 and Section 3. And the reference I've put down there, NHS Trust and ST, is actually a way for me to easily quote what Mumby said in Local Authority X and MM in 2007 about belief. What interests me here, and I think what is interesting generally, is the intersection of belief as part of what the general requirements of understanding of and ability to use and weigh information, and insight. Insight is a word that's used much more frequently in the Mental Health Act, in Mental Health Act proceedings and reports and so on, than it is in Mental Capacity Act proceedings, as far as I understand it. But I would like to know what the difference is and what the similarities are between those things, because if there is, if belief is relevant, even though it's subsumed into other aspects of the tests under 2 and 3, and if belief in some way crosses over to insight, then I think that you can see that if somebody who lacks insight could also be caught by the definitions in 2 and 3 of the MHA, that would mean the crossover between the MHA and the MCA is enormous, because it's very common for patients to be detained in hospital under the MHA because they lack insight into the fact that they have a mental disorder, the fact that they need treatment for a mental disorder. Obviously, those two things allied. And so where does that leave us? So it's not a proposition so much as a question, but it's a question that I don't see has been clearly answered anywhere yet. And it's a question that does need answering, because it impacts directly on how much crossover there is between these two acts. Second point, the MCA is an alternative to MHA detention. This is quite straightforward. There's two ways it could be relevant. First, because a DOL in a community setting may well be less restrictive, the minimum effective restriction for the patient compared to detention in a hospital. By this I mean that there are it is relevant that somebody would prefer to be in a house with a front garden, a front door that goes onto a street, rather than in an institution. They are both in some ways institutions, but my professional experience is people value approaching normality in any way that they can. And being detained, particularly in a large psychiatric hospital on a ward, is a very long way from normality, from a normal lifestyle. And being detained in a relatively small house in the community with a front door is something very different. And I think that is relevant to what is restriction, to the level of restriction. The second point is because of 72(1)(b), this is just a hard-edged point of law. One of the criteria for detention in hospital under the MHA 1983 is that it is necessary that the patient receive treatment in hospital for their own health or safety or for the protection of others. Necessary, and that's been emphasised. There was this isn't in the handout, but there's a case called Reid and Secretary of State of Scotland, 1999, off the top of my head. Lord Clyde said, it's a famous quote, "The standard here is one of necessity, not desirability. If you've got an alternative, it ain't necessary." End of. But underpinning both of those is this proposition: both statutes may be apt to authorise the achievement of the same objective, treatment and or risk management of a mental disorder, where authorisation is needed. And authorisation is the key. Most of you will be familiar with the case of MM in the Supreme Court a few years back. That was all about authorisation, what can and can't be authorised. The whole point of that was that the Mental Health Act does not authorise on, for example, a conditional discharge or a CTO, it's also the PJ case, a deprivation of liberty in the community. MCA does. That's why it's so significant. Third point, symmetries between aftercare and a DOL's care plan. The MCA is available where a person, quote, is unable to make a decision for himself in relation to the matter because of an impairment of or a disturbance in the functioning of mind or brain. I know I'm probably preaching to the choir in relation to this, but it's important to bear that in mind for the next point. Aftercare, according to the Code of Practice to the MHA, is basically the same thing. You see the quotes. So there's a symmetry there. Again, I'm not sure whether this has been investigated very closely, if at all, but it's interesting to think about what a DOL's care plan would involve and how different it is, if at all, from aftercare upon discharge from the MHA. So, I mean, I say that, I mean, there is a caveat because there has to, everything I'm saying, there are caveats to. An aftercare plan approved as being in the best interest of the patient will not always precisely equate with care or treatment related to the impairment or disturbance in the functioning of the mind or brain, the MCA definition. But in many cases it will. So in those cases, aftercare dolls may meet the same needs, have the same objectives, and actually, apart from the doll part, achieve the same thing in the same way. It's interesting, Jones, again, in this edition, lists grounds that don't justify detention, don't justify discharge from aftercare. You can look at the notes in section 1172 of the 25th edition. So for those of you that aren't necessarily familiar with the Mental Health Act, there is a duty to provide aftercare where people are discharged from most of the compulsory sections, the detention sections in the Mental Health Act. But as you would expect, that duty, which is joint between the local social services authority and the health body, that duty only lasts as long as there is assessed to be a need for it. Okay. So there comes a time, in some cases at least, where the assessment is that the duty to provide aftercare is discharged. But, and this is why this is important, it is not one of the reasons to discharge aftercare that the person is subject to dolls. So again, those two things are fitting together. Helen is going to talk, as I understand it, about a cop case where a judge, Eldergill of all people, who, I mean, in the country probably is the person that knows both acts better than anyone else, certainly better than me. The judge refused to consider an advance authorization with a view to discharge into a care plan, discharge from the MHA into a care plan authorized by the MCA. And that just seems, I don't understand why he would have done that. But in particular, it seems to jar with the approach endorsed by the upper tribunal in a case called MC Insignia Care, which is the key case, and I'll come on to it. Because in MC Insignia, paragraph 29, upper tribunal Judge Jacob said this: how can the necessary mental capacity arrangements be made, that is made for somebody that is being discharged from the MHA into dolls? So that's the question he's asking himself. His answer is, if the mental capacity issue has already been dealt with by an advance authorization, the tribunal may be able to proceed to a conditional discharge without more ado. So you've got an upper tribunal judge saying advance authorization is a legit way to do it, expressly. And as I understand it, you've got a cop judge saying no, not having anything to do with that. Two sisters, they're not speaking to each other, again. This is basically an example of how the two jurisdictions should run in parallel and should complement each other, but instead often seem to be just running off wildly in opposite directions. The underlying duties are clear. I've set out, am I running out of time?
You're fine.
Yeah. I've set out a part of the code to the MHA towards the bottom of page 2. Paragraph 3310. This is all about when planning for discharge should start. And in this way, there is some sympathy between the approaches taken under the MHA and under the MCA. So the approach taken under the MHA is exemplified in this quote from the code at 3310. The planning of aftercare needs to start as soon as the patient is admitted to hospital. So the idea is it's a constant assessment of whether detention is needed, and if it ain't, what the alternative would be. But the thing is, it isn't if it ain't, actually, I've said that wrong, because the point is, it's very often about alternatives. So as part of your consideration of the responsible clinician or tribunal's consideration of whether detention is needed, you take into account the alternatives to detention, which may be less restrictive. And that figures into your decision, or should, about whether detention continues to be needed. So that's the code's approach to it. But it gels really nicely with principles in relation to the Mental Health Act that were identified by the Secretary of State, the Council for the Secretary of State for Health and Social Care, in a very recent COP case, the Manchester case, right at the bottom of page 2. So the barrister for the government set out various principles, and the two, paragraph 32, J and K, are really interesting because they exactly match that. What the Secretary of State for Health and Social Care said was the appropriateness of continuing a detention under the MHA should be kept under continuous review by treating clinicians. The question of whether it's necessary to detain a person under the MHA for treatment is not determined by absolute descriptions or metrics, but will depend on whether there's a less restrictive means available to deliver the person's treatment. And that also accords with principles in the cases of MC and ML, which I'm going to come on to. But you see the point. It's like where you've got somebody detained in hospital and where the MCA is or might be an alternative for the provision of care, treatment, risk management, then it's something that has to be considered and kept under constant consideration, because it potentially means that the patient is no longer detainable under the MHA. So, fourth, how does this work in practice? Variably and sometimes not at all is my short answer. The good thing for you is that pretty much all of the work has already been done in one judgment by one judge. And this is the MC and Signet Behavioural Health Limited, blah, blah, blah case. This is a judgment of Upper Tribunal Judge Jacobs. And it's a long judgment, but the reason why it's long is because he went through all of the central cases, quoted from them, said what they meant in a paragraph or two, praised them, and said why he agreed with them. It's basically like a ready-made skeleton argument about how the MHA and the MCA fit together. I really recommend it. It's a beautiful judgment. So your work has been done.
Which one is that again, sorry?
It's the MC and Signet. So if you see page 3, oh, it's up there as well. Okay, cool.
Oh, yeah.
So, I say it's useful, that's an understatement. And then paragraph 28, he says this, I mean, the quote's there, these factors combine, but this is really important language. These factors, or those factors, he's just reviewed all the principles, combine to provide the imperative, the first tier tribunal, that's the Mental Health Tribunal, to apply the 1983 Act in a way that allows a patient to be discharged if there are means by which the patient's case can be appropriately dealt with under the other legislation. 2005 Act is such legislation. If a patient's case is to be dealt with correctly, in other words, not an error of law, under the 83 Act, and fairly and justly, which would also, if it's not done fairly or justly, would constitute an error of law, under the tribunal's rules of procedure. The tribunal is under a duty, look at how strong the language he's using. The tribunal is under a duty to find a way that allows both acts to be applied in a coordinated manner. It would be nice to, when Eldergill was sort of saying, I ain't going to do it, slap him with that. Because he's interfering with the exercise by a tribunal and by a responsible clinician of their duties.
That's what he didn't want to do.
Yeah, I mean, I really don't understand that. Anyway, yeah. It's so interesting. And he also, Jacobs, this is where this judgment gets a bit weird. He also gave some broad guidance on how the imperative that he described should be achieved. He did it very shortly, and he did it. I mean, I like the way he writes his judgments, but. For those of you that aren't familiar with this particular upper tribunal judge, he said there are two approaches, and he called one ducks in a row and one the two hats. What he means by this, ducks in a row, is like, okay, you're applying for conditional discharge. The patient has or may lack capacity which would allow authorization of a community dole as part of a conditional discharge care plan. But you ain't got that authorization. So you have to adjourn or defer the tribunal proceedings, go to the Court of Protection, try to get your authorisation, then come back to the proceedings. In other words, as each issue comes up, you shoot it by going to the particular court or tribunal, get that done, and then move on to the next one. The better approach is his two hats approach, where he said where you've got a judge who has two tickets, a COP ticket and a tribunal ticket, they can do the whole thing at once. I don't know whether that's ever been done. And one also needs to remember that tribunals have 3 judges, not 1. So who's making the decision? Is the medical member of the tribunal and the lay specialist member of the tribunal, have they also got a COP ticket? No, they haven't. Does that mean they're allowed to make the decision, or is it just the judge? If it's just the judge making the decision, then is it a legit and lawful tribunal decision, because it's a tribunal of one of them rather than all 3 of them? You see, every time you think you've thought of a solution, even if you're an upper tribunal judge, 10 more problems crop up. It's so tricky.
Why can't they have a standard?
I mean, they could. That would be one way of doing it. But if there's a dispute about it,
Okay, yeah.
you know, and I mean the dispute needs resolution. And if you're in the tribunal, it may be that there is a dispute about it, which is why you're in the tribunal rather than the RC writing to the Secretary of State. In which case, it needs to be heard and resolved.
Okay,
yeah. So the problem is the tribunal itself isn't comfortable. I'm only going to mention this briefly. This is a case of mine from earlier this year. I ran all of this, put in MC, explained in really straightforward language why it mattered. All the witnesses agreed the patient lacked capacity in every relevant area in relation to every relevant decision. Tribunal just completely ignored it because it freaked them out, because it complicated. And I kind of don't blame them for being freaked out by it, because it is so complicated, and it's not sort of like we're here to decide yes or no today, and that's the end of it. It isn't like that. It's we're here to decide maybe yes, maybe no. We need these further decisions, and there's complicated case management and procedural consequences from all of this. They totally failed to engage with the point, but we successfully appealed. This was Upper Tribunal Judge Church. The reason why I've stuck this in, because there was a really important concession made on behalf of the Secretary of State for Justice in relation to what can be achieved for a conditionally discharged mental health patient, a forensic Part 3 patient, under a conditional discharge that contemplates a dole. The Secretary of State conceded, and this is in the judgment, but there was more detail in the Skelly, were ML, the patient, discharged from hospital, the MCA could be used to authorise a medication regime to the extent that he lacks capacity to make decisions relevant to that. And the evidence was all one way, that he did lack capacity. It kind of takes us back to the first point. He lacked insight into the fact that he had a mental disorder, into the fact that he needed treatment for that mental disorder, and that was also taken to be a lack of capacity, which would, according to the Secretary of State for Justice, in theory at least, allow the invocation of the MCA. I've put in Church's, parts of Church's judgment there. I'm not going to read them out because it's boring, but it was basically an endorsement of what Jacob said and the approach that Jacob set out in MC and Signet. So we're back to MC and Signet. Can I just mention one more thing from MC and Signet that I forgot? I think it's in here. One of the quotations you'll see in there is a quotation from a decision of Mrs. Justice Leven. Is it Leven? Is that how you say it? Yeah. In the Birmingham City Council and SR case. And this is really important because there was a dispute between the government, the Secretary of State for Justice, and others about a sort of academic dispute about whether the MCA is apt to be used in cases where the patient, as a result of mental disorder, disability of mind, whatever you want to call it, is a risk to others. And there was a case called ZZ, decision of Mrs. Justice Moore, which was then endorsed by Mrs. Justice Leven in the Birmingham case. And she said the Secretary of State is wrong. in guidance that he issued, which isn't really worth reading. And that it is strongly in the best interest of a patient who is a risk to others as a result of mental disorder not to commit an offence. So risk management of risks arising from mental disorder can be part of a best interests declaration if there is a lack of capacity, which is hugely important. Final point, practicalities. This is a concern of mine going forward. And again, it's because the two acts don't speak to each other, or the case law of the two acts don't speak to each other. In the last few days, I've read a lot of judgments from the upper tribunal and the admin court in relation to the Mental Health Act, and judgments from the Comm. The judgments from the mental health side of things that I've read have been about the MCA, and the judgment from the Comm have been about the MHA. And it's really interesting that neither of them hardly ever mention the other ones. It's like, bless you again, it's like they're sort of, they're looking at, so you read a Comm judgment about the Mental Health Act, it is full of citations of the Code of Practice, the statute. There's hardly ever mention of the case law about what those things mean, and vice versa. So the Manchester decision, which I've already quoted, I think is part of this. I'm not sure I agree with it. It says that there's always an alternative detention. Tick, I agree with that. It says that if an alternative will do instead of the MHA detention, then it must be pursued. We've heard from MC Insignia and Jacobs. Tick, that's correct. But it also says that if the alternative takes time, the MHA detention remains lawful in the meantime. This is the bit that I think is problematic. And this is why I say it may be that practicalities are trumping principle. Because the danger here is that the judgment might be seen as endorsing detention that achieves nothing more than stasis, a kind of holding measure, while better or lawful ways of dealing with the patient's needs are found. And I'm not sure that's enough to satisfy either the domestic law or convention law. And I've set out why. There's the really surprising thing in the Manchester case is there is no mention whatsoever of Rumen and Belgium. And for those, I was going to say for those that haven't read it, I recommend reading it, but I really don't because it's enormous. It's 50,000 words, but it's a really important judgment. It's a judgment of the Grand Chamber and completely refigured how the court sees the Article 5(1)(e) lawful exception to the right to liberty, completely refigured. In particular, setting out the need for there to be clear, individualized treatment objectives that lead so far as possible to the patient being able to regain their liberty. And so I think there's a tension between that principle, which was then endorsed in the upper tribunal in a couple of cases, SLL and Priory, and SF and Avon from earlier this year. A tension between that principle and this idea of the MHA being used as a holding power while other alternatives are arranged. Because it must be, the whole point of Rumen is it's much more than just a holding power. Obviously, depending on the individual facts of the case. And I wonder there that the principles of the Mental Health Act have been relegated. That's it.
Wow. Thanks very much. Thanks very much. I mean, glass half full, glass half empty. Part of what you said gave me some hope that actually the sisters, statutory sisters, do sometimes speak to each other. I think His Honour Judge Burrows in the Manchester case does speak about both acts. He didn't want to use the inherent jurisdiction. He doesn't like the gap that people can fall into. But you're right. practicalities are ruling everything at the moment. The most recent guidance the other week was basically saying, you know, where we said that the judges are going to have oversight on all these unregulated placements for young people. Well, actually, the judges aren't going to have any oversight about that anymore because we can't handle it. We've got over 1,000 cases in the National Dolls Court for those young children, and the judges don't want to be in the resource arena. So you're absolutely right, and there's difficulties about retaining the principles that underline the decision making. I appreciate it's been quite a long day. People might feel a bit warm in here, and you can hear glasses clinking next door. So I'm not going to speak for over long, but just a couple of things. Following on from what Roger said, I mean, the Care Quality Commission did its own tiny bit of investigation looking at who's doing what. Are people using the MHA or are they using the MCA? And what they found was a variable understanding of the interface, understatement possibly, where both frameworks could be used. Not always clear how staff decide that using the DOLS framework would be most appropriate for a particular patient. Obviously, there's tons more that could be delved into in that if anyone was going to do any research about it. But there is a suggestion that because everyone thought that liberty protection safeguards were just around the corner and were just about to come in, loads of monthly meetings, departmental meetings, training, getting people up to speed for the LPS, all abandoned. And in that time period, the keeping people fresh and having DOLS and these tensions, whether it's Mental Health Act, Mental Capacity Act, keeping everyone up to date with that has just gone by the by, it would appear, without casting any aspersions. Anyway, so this is not the District Judge Aldergill case, but it is a real case where a forensic patient had paranoid schizophrenic. He was in his 70s, detained under section 3741. Conditional discharge, I say usual conditions, residence at a particular place. It was 24-hour supervision, comply with medication, meet with your responsible clinician, etc. Be subjected to regular blood and alcohol, drug testing as required, only consume alcohol within reasonable limits or within the limits set by the RC, whatever the RC drinks, leaving that aside. Anyhow, so what you had then was P, and the social worker in that case worked really hard, found a place that could meet P's needs. He was mobile, he had ability to walk around unaided and leave the place, which he did 2 or 3 times a week, left the place about 10 in the morning, came back each afternoon, but went about doing whatever he was doing in the town where the placement was. And the no standard authorisation. The only thing that kept him there were the conditions of the conditional discharge. And then his cognition altered. The social worker, I think, got a bit twitchy and didn't want him recalled. I mean, that was the driver behind it. Didn't want P to be recalled. Wanted there to be a standard authorisation, asked the care home to get standard authorisation. And that assessment found that P, in fact, lacked capacity on their assessment to decide to live in this place. And so there was a challenge then about, well, what's the purpose of this standard authorisation? Because he's going out and about. He is not subject to continuous supervision and control, which is one half of the acid test. But ultimately, what it was determined was he did fall within the acid test because he wasn't actually free to leave. He couldn't self-discharge. He couldn't go and live somewhere else, etc. So it did fall within the continuous supervision and control for the purpose of the fact that he wasn't free to leave. If he did leave or he didn't return after he'd taken himself off to have his lunch downtown or whatever, then either he'd be recalled or at risk of being recalled, or the police would be notified that he was missing. So that's him. In relation to some of the other cases where there is an intersection, The Northumberland case, same judge, Judge Jacobs. This was a precursor really to the MC case that you've spoken about, Roger. And in that case, before I deal with that, I just wanted to say about the standard authorisation for, I'm sure everyone here knows, but conditions can be attached to the standard authorisation. So you can have all your conditional discharge conditions, and you can have conditions attached to the standard authorisation, not necessarily creating an increase of restriction, but generally the conditions might be every time P objects, you must make a note of it or whatever. And in that real case, he'd never unpacked his bags and he was permanently objecting but wanted to be absolutely discharged. So he said, I'll stay in this care home until the tribunal absolutely discharge me. Anyhow, blah, blah, blah. Yes, the Northumberland case. So the same judge, as I say, Judge Jacobs, powers to deprive a person of liberty under both statutory sisterly regimes. They can't, in his view, be kept so distinct, but the principle that was relied on, or that he brought to the fore, in my view, was the principle of least restriction. That's what it's about. How can this person, whatever their mental disorder or lack of capacity, how can they live in the least restrictive way? And that was the reason that although the code applies to the Mental Health Act and not relevant to the interpretation of the Mental Capacity Act, you can't escape the fact that the principle of least restriction must apply to the deprivation of liberty. And it's because the first tier tribunal didn't engage with that argument that was put forward in the case that, well, this person actually wasn't a conditionally discharged patient. There's an error in the judgment. It was a Section 3 detained patient. This person could be receive their treatments, not necessarily for them to be in hospital. They could receive this treatment in the community. And because the first tier tribunal didn't engage with the concept of a least restrictive alternative, or didn't give adequate reasons for why they dismissed it and didn't engage with it, that's why the decision was set aside and it was remitted. Don't think we've got time to go into all of this, so I'm not going to go into the PB case, another drink related. I'm not desperate for alcohol, honestly, but it is another alcohol related case with Mr. Justice Hayden trying to work out whether or not PB has got capacity or not, and is capacity being used to basically control somebody's drinking. That's effective. And he said, actually, PB has got capacity. He can decide. He knows the risk that he might get kicked out of this care home or whatever the establishment was because he's breaching rules. That's his decision. Might be very unwise, but that's up to him. And didn't find that, which what the local authority, I think, wanted to find, a finding of capacity, so there could be a best interest decision flowing from that to restrict PB's access to alcohol. Anyhow, we know that it's Schedule A1, which is the standard authorisation, only applies to care homes and hospitals, not to supported living. That's where the Court of Protection have to authorise in the community the authorisation of P's liberty. So there are two different things, just to be aware. Section 21A doesn't apply to somebody who's trying to get home and have a care package in their own home or be looked after by one of their family members. That has to be authorised by the court. So this is the Eldergill decision. So District Judge Eldergill, no slapping allowed apart from the person's left their mobile phone. But no, feel very protective towards Judge Eldergill. So especially if this is being recorded, he's a fabulous judge.
He wrote a great book as well.
Yeah, he did.
He wrote the original book on mental health review tribunals, which people are still citing, and I still look stuff up in.
Exactly. So no slapping.
Plus, sorry, can I just say one more? In the introduction to his book, he talks about how he himself had a mental disorder, which is a really important thing, I think. Mm-hmm. Anyway, sorry to interrupt.
That's okay. So basically, in this case, there was a gentleman in his 90s who was in a psychiatric hospital under Section 3. The reason he was there was because he had, with his wife, benefited from a domiciliary care package at home. There were loads of children. and everyone wanted the parents to be looked after at home. Very high level of care need. Unfortunately, it was alleged when he aggressively hit out at a carer during a period of personal care, and that carer subsequently, very sadly, about 3 weeks later, died, and there was an inquest. So that's the kind of context in which, when that happened, care package ends, wife goes into care home, dies within a few months, father or husband P is detained under Section 3, then becomes eligible, if you like, for discharge. Eligibility is a complete buzzword, I think, in a way. I'll try and steer away from that. But basically, he was no longer detainable under the Mental Health Act, and the question arose, okay, what happens? So that was the sort of context, but the responsible clinician wouldn't discharge him. Not because she didn't want to, and she came to court to say that with the right care package, he could be discharged home, but there would need to be some parameters around that. And what District Judge Eldergill basically said was, this is all very interesting, but you're a responsible clinician and you've got powers under Section 17 to trial this with P at home, with care package, etc., etc. And I think what he was trying to do was flush out all, respect to anyone from the local authority here, but flush out the local authority's resistance to commissioning that care package in the family home because of the context of what had happened previously. So he was trying to say, okay, responsible clinician, make it happen. You can make it happen. You take the decision to grant Section 17 leave with very strict parameters, and you pressurise the powers that be to say he can go home. You provide the care package. Let's see what it looks like. Come up with a care plan, and I'll say yes, he can go home for 2 weeks on Section 17 leave, and if it works, I'll renew it, and then eventually we can do the ducks in a row process. So he wasn't, District Judge Eldergill wasn't saying in a fit of pique, I can't do it. He was basically, in quite a nuanced way, saying, don't make me, the Court of Protection judge, the person who's going to authorise a deprivation of liberty for this man in his own home, given the background, and no one's giving me a care plan which can help satisfy me that his needs are going to be met and everyone's going to be okay with it. So that was the context in which it happened. And then last slide, Roger's already mentioned the Section 117 aftercare. I've put this in here. I know it's a slightly incongruous about the House of Lords. I'm actually old enough to remember it, looking around the room, lots of young people, but anyway, no power to require any psychiatrist, this is the judges, can't require a psychiatrist to act in a way which conflicts with the conscientious professional judgment of a psychiatrist. And the reason I put it in is because in a judicial review case I was involved with, the conditionally discharged patient who MOJ had given leave to stay in his own home 3 nights a week, but he couldn't be discharged because no community psychiatrist would take him on. And we had the director of the trust at the first tier tribunal, all of it, with the tribunal really trying to force the trust to make it happen. And so it's worth remembering on the risk side of things that risks and resources are things which impact practicalities, in my view, and subvert the application of principle. So looking at the principle on aftercare, we now know, because the Supreme Court told us, that a person who is detained in Area 1, all those aftercare duties that everyone fights over, whether it's social care, health care, which local authority, etc., if they are discharged and then they move to another part of the country, then it's the subsequent discharge in the new part of the country which has to deal with discharge planning at the point of admission, and work through, rather than try and pass the buck back to where the patient used to live or used to have ties under any kind of ordinary residence type of interpretation. And the reason I mention it is because where you've got cases where there's an acquired brain injury or something like that, you've got different local authorities, and now formerly CCGs, now ICBs, who are arguing the toss over who's going to pick up the tab. And the split isn't always 50-50. And so it is useful to, particularly with ICBs, to say, fine, you want the local authority to be the lead statutory body on this, but actually, unless you get involved, we're just going to join you in the Court of Protection proceedings. The ICB doesn't want to be joined, fair enough, that's a stretch on their resources, so you're not necessarily making a problem go away, possibly compounding it, but without some significant involvement from health, then what you're risking is a patient being readmitted. And the whole purpose of Section 117 is to prevent a mental health deterioration and then a readmission into psychiatric care. So it's a bit of a, to me, it's just a false economy for health to say, well, actually, we're not doing the lead stuff here. You go and choose where they live and you choose this and you choose that. Well, hang on a second. This person's actually got some mental health needs as well. So we need some input from the ICB, please, to make sure that they stay well as they can in the least restrictive environment, and that is in the community. And I think that that's the end.
Thank you.
To thank Roger again for sharing his expertise, and I need to go and read his handout, and thank everyone who's joined us online. But I do hope that this conversation can demonstrate that there are ways in which these statutory sisters can speak, and practitioners need to be involved in furthering it. Mr. Simbler KC is shaking his head, but possibly, go on, what would you like to say?
It's interesting, isn't it? Because it's about differences of, it's partly differences of institutions, both who's deciding it and how they generally decide things that go on in front of them, and the institutions involved in care. So like local authorities often want to be able to go and telling people what to do and manage their long-term needs and be involved in long proceedings with courts adjourning or mental health review tribunals or mental health first-tier tribunals. Is he detainable today? That's our task. Yes, he is. No, he isn't. And clinicians involved in that judgment about what the person's needs are in a sort of a set of statutory conflicts rather than a sort of holistic sort of how do we tell this person what to do, and that's another reason these people don't talk to each other, because actually they're different places where they're resolved and different personnel involved in the disputes.
Yeah, that's right. Can I just, I know some people are leaving, but is there, and we might have one or two moments. Does anyone want to ask anything?
Roger's saying that you shouldn't be detained under the Mental Health Act if there's a less restrictive way of detaining you, for example, the Mental Capacity Act. That's right?
Yeah, I mean, that's, if it's less restrictive, I don't.
If the statutory criteria aren't made out, I mean.
Well, yeah, okay. So this goes to the, point 2 on the thing. I mean, I don't think I would be confident to say that every doll's situation would per se, just because it's not in a hospital, be less restrictive than a hospital. One can conceive of, for example, a sort of rehab unit, which may be less institutional, a rehab hospital, less institutional, or as institutional as a place in the community, a large nursing home, for example. But the basic principle is, as Helen or Stephen said, is, this is conceptually difficult, but like the criterion in 72 1B2 is the patient must be discharged. The tribunal has a duty to discharge if it isn't necessary for the patient to be treated in hospital for their own health or safety or for the protection of others. This is a really hard-edged way to analyse it, but it's there in black and white. If you've got two ways of doing the same thing, even if they're roughly of the same level of restriction, then according to 72(1)(b)(2), you do it in the way that is not hospital because you've got another way of doing it, so hospital ain't necessary. I fear that's a bit simplistic.
The qualifying requirements of standard authorization, one of them is the mental health requirement. And isn't that basically saying if you can be detained under the Mental Health Act, then you shouldn't have a standard authorization?
Yeah, but we're going around in circles because then 72(1)(b)(2) is saying that you can't be detained under the Mental Health Act.
It's actually mental capacity is the qualifying requirement under the standard authorisation, and the psychiatrist will say whether or not this person has capacity or not. If they have capacity, then you're not in the court of protection at all. So capacity, if you're gonna if you want to think about it slightly differently, capacity is in the middle of Mental Health Act and Mental Capacity Act. So if someone lacks mental capacity, that will have an impact on discharge options in the mental health sphere. In my view, that's one tiny aspect of it. But the mental capacity qualifying requirement is essential for it to be in the court of protection in the first place.
Or onto the MCA, even not in the court of protection.
Yeah, absolutely. It's got, you can't, without a lack of capacity, there's no jurisdiction for the court of protection.
So the example is, for example, you have schizophrenia and are autistic. If your schizophrenia is treated, you would have no mental capacity potentially, so you would fall into court of protection. But just because you are schizophrenic and then you are treated for your schizophrenia, but you aren't autistic, you would be assumed to have capacity when you leave the mental health hospital. So that is, I think, would that be a fair?
I don't know, because I mean, this
you would have capacity once you get discharged if your schizophrenia is treated.
It's a bit like the diabetes, the serious treatment of diabetes things.
I don't think you can say that everybody,
not everyone,
with schizophrenia, or even many people with schizophrenia who, for example, are discharged on a CTO or on a conditional discharge, necessarily have capacity. It depends on so many individuals.
Sorry, but I was trying to find an example.
Yeah. No, it's not that.
There is a difference between physical health and some of the treatment decisions that are on there, like the SF case. You've got treatment for physical illness in a hospital separately from any consideration of mental health. So someone who's treated for their diabetes or whatever, fine, but actually the schizoaffective disorder is not amenable to medication, and so it's that cognitive impairment which jeopardises the capacity.
No, you're right, and there's also, I think, one of these cases, I think it's either the Manchester case or the JB, no, not JB, the ST case. The judge pretty much starts the whole analysis by saying that neither act has primacy. The question is, what is the least restrictive, most appropriate means by which the treatment and care and or risk management that the patient needs can be provided? Because I think your question actually identifies one of the many problems here where the acts don't ring gel and where you can end up saying, oh yeah, but the MCA says this, so it's got to be the MHA, but the MHA says this, so it's got to be the MCA. And I think probably the sensible way through is to say, given that what Jacob says, page 3, the quote from paragraph 28 of MC, given that there may be means by which the patient's case can be appropriately dealt with under other legislation, the 2005 Act, the tribunals and the Court of Protection have to consider which is the appropriate alternative by reference to the law, but also by reference to the patient's welfare, health, safety, treatment, risk management.
But that sort of begs the question, because the judge in that case might have said that because he was a judge sitting in the Court of Protection, whereas if this happened to be being litigated in the tribunal, you might have a very different starting point and approach.
Yeah.
And that's what, and there's not really any way of sort of saying, well, you should be in, who initiates these proceedings and in what circumstances and in what forum.
But it is, I mean, it's a really good question, and I haven't seen any judicial or even guidance answer to the 72(1)(b)(2) problem. This is, I mean, one way you could analyse this is say it's been caused by the word necessary or necessity, the concept of necessity.
But that has to be right in order to comply with Article 5.
Well, that's
doesn't it? I mean, like, that's the thing that has to stay.
I mean, this is, I mean, yeah, how useful today has been, we basically say it's all completely woolly, nobody really has a clue, including the judges.
A few of them are trying, and I think that with Roger banging away, as you will, I'm sure, in the tribunal, can maybe revisit this thorny topic.
No, but I mean, go back to what Jones said. He said, this is going to continue to develop. It's never going to be resolved because you have questions, really good questions like this, where it's, unstoppable force, immovable object. What happens?
What does he say in the latest edition?
Do you think the draft legislation in Northern Ireland might be a way of solving it? Because there's a proposal to have a unified form of mental health and mental capacity legislation.
You came in late. That's what I said to start off with. It makes no sense, Tim, to have, this is the Jones is saying this, lots of people are saying it makes no sense to have two acts. But then, they can barely, the King's Speech didn't include the new mental health. So, I think we're, asking for unicorns and rainbows to ask for that. It just ain't going to happen.
It looks like people are going to be coming back. Thank you very much, everyone.